I'd like to advise anyone in the gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. It's not permitted to take photographs or record any part of the meeting. Clark, are you chair? Clark, are you aware of any apologies?
No, sorry, not at the minute.
Okay. Any members indicated they were done by Zoom? Okay. Declarations of interest. I would remind you of your responsibility to declare any interest in any of the items under discussion today, matters of interest. Does any member have any interest to declare in relation to any of today's agenda items?
I declare an interest in a partner in a farm business.
Excellent, thank you, William.
Executive of a small farm and owner of a small farm.
Thank you.
Again, a small farm holding.
Small farm holding. Okay, thank you very much, gentlemen. Agenda item 3 is chairperson's business. I refer you to page 7 of the pack to correspondence from the Minister dated 3rd of October regarding an AFB data breach. This was emailed to you all by the clerk on Friday evening. Members of the Department was advised by AFB that data relating to retailers and individual producers had been disclosed in response to a Freedom of Information request. An investigation is underway and the Information Commissioner's Office has been notified. Updates will be provided in due course and the senior AFB team will be available to brief us in more detail in the coming weeks if required. Have you any comments to make, or are you content to note at this stage? Content to note. Thank you, members. Members are referred to page 9 of the pack.
Should we consider bringing AFB in? I mean, I'm happy to be guided by colleagues, but if members were minded to have a conversation with people around this, I think it's something we should seriously consider.
Yeah, they've indicated that they're willing to brief us, so I'm content to make sure that happens.
This is AFB itself, yeah.
AFB, yeah. Okay.
Second that there.
Thank you. John Daglan. Okay, members are referred to page 9 of the pack to an invitation to a Joseph Rowntree Foundation roundtable event at the MAC in Belfast on Friday the 17th of October for a discussion on a poverty-free future for Northern Ireland to mark the International Day for the Eradication of Poverty. Unfortunately, I'm unavailable to attend, and I agreed to extend the offer to attend to the Deputy Chair in the first instance and then the committee, and I know that the committee is very acutely aware of the rural impacts of poverty and the disparity that exists there. So that invitation is in your packs. If anybody is free and available to go, if they want to respond and just alert the clerk, that would be much appreciated. Item number 3, I refer you to page 4 of the table papers to the Minister's oral statement he made on Tuesday regarding the update on the highly pathogenic avian influenza at a commercial poultry premise outside of Omagh. This is the first suspected case in a commercial poultry premise in Northern Ireland since the last confirmed case in late February 2025, and we should all be aware of the need for vigilance, high biosecurity, and for farmers to immediately report any unusual symptoms. I think it was a useful session in the chamber, and the Minister did take a series of questions from us. Have any of you any comments, or are you content to note? Yep, thank you, members. Members, in relation to the Dilapidation Bill, final plans are now in place to have an online meeting with some members of the Youth Assembly to hear their views on the bill. The event will take place on Tuesday the 14th of October on MS Teams. That's next Tuesday at 6:30. It's online, guys. There'll be introductions and a few words of welcome from myself. There will then be a short presentation on the bill from the committee team, and then the Youth Assembly team will run the remainder of the event with an estimated end time of 7:45. Following the meeting, the Youth Assembly Secretariat will issue the committee with the report as soon as possible. Members, for the Youth Assembly to know who is likely to be online from the committee, I would be grateful for confirmation to the committee team that you intend to join the meeting. If you're available, a link will be sent out prior to the event. Just to make you aware, the Youth Assembly does have representation from right across Northern Ireland. It's very, very well served in terms of its Section 75 commitments. They're a very engaging bunch, and the very fact that they are interested in this bill genuinely impressed me. So if you would be available, I would appreciate if you could, but I understand it's an unusual time too, depending on plenary. Yeah. Okay, but it'd be really good if you could let us know. Item number 5, I refer you to pages 58 to 76 of the table papers for the committee's draft end of session report 24-25. So a lot of work has actually went into that, members. Have you any comments? Are you content that it's published? If you wish to have more time to consider it, we can hold off agreeing it until next week. It is a substantive report. I don't know if you've had much time to look through it. It's a good piece of work. Do you want to leave that till next week, just to give you another few days to read through it?
Yeah.
Okay.
Just to make, just part of it strays into before I was chair, and obviously things took a turn for the better when I became chair. for the minutes, are okay. Okay, guys. Didn't get a seconder there, Declan. Thanks. Okay, matters arising. Agenda item 5. I refer to the packet, page 25 to 26, for a response from the Department dated the 3rd of October in reply to our letter of the 19th of September. Yeah. No, we need to do the minutes first, don't we? Okay. Agenda item 4 is the draft minutes of our meeting from the 2nd of October. They're page 12 to 23 of your pack. Any comments to make in the minutes? And if there's no comments or issues, then I'll sign them as drafted. Thanks, members. Okay, that's okay. No, it's like me, it's half working. Okay, agenda item 5, matters arising. I referred to packet pages 25-26 for a response from the department dated 3rd of October in reply to our letter which is dated 19th of September regarding an update on the progress of the farm sustainability standards and penalty matrix. As you will recall, we were briefed on the SL1, the farm sustainability standards regulations, last week, and we agreed that we would consider our support or otherwise for the SR when it was laid. In response, the response states that Minister Muir has made final decisions required to complete the development of the penalty matrix. Have you any comments? Are you content to note? Okay, thank you, members. I refer you to table papers starting at page 12 for a response from the department dated 7th of October in reply to our letter regarding the bovine genetics genotyping scheme regulations Northern Ireland 2025. Members, as we requested, a step-by-step flowchart setting out each step of the proposed scheme that has been prepared, and it's at page 15 of the table papers. It's excellent, it really is good, because I know there was a lot of to and fro in terms of questions and certainty that members were seeking, so that's a very useful flowchart. In response to our query regarding communication strategy for older farmers, the department states that there is a programme of communication channels to ensure farm businesses, including older farmers, are fully informed of timelines and the steps they need to take to prepare, including awareness events and hard copy publications. Training will also be provided to industry professionals to assist their farm business clients to register participants in the project. That was a piece that you had specifically raised, William, I think, and around how to communicate with older farmers to ensure that they have certainty around that information. So that's something that just needs that wee bit of from yourself, I suspect. You'd really interested in that. Yeah, that was a good piece to pick out. Members, in response to our query regarding engagement with the Agricultural Policy Stakeholder Group, otherwise known as APSG and Sustainable Ruminant Genetics Limited, the department provides details of past engagement covering topics such as proposed penalty levels for non-compliance and farm sustainability payment conditionality. As a result of the engagement and in response to concerns raised, DAERA states that it agreed that genotyping would be removed from the planned FSP conditionalities. Are members, any comments to make on that? Okay, thank you, members.
We would still have some concerns around the penalty matrix.
Yeah, we'll have another discussion when they put the SR. So okay, and if there are any specifics, William, in regard to that, we obviously would like to see those things ironed out in advance. So if you,
it's a fear of the outworkings of it. It's,
yeah.
You know, everything can look good on paper, but
yeah,
realities on the ground.
As you've point, I think there's another piece of information we're waiting coming back on that in terms of the minor infringements, and we asked for a response on that, didn't we? Yeah. Okay.
Letter went off.
Okay. And that hopefully will give us more evidence, and then we can look at that from there. Okay. So, members, item number 3, referred to table paper starting page 17 for response from the department dated the 7th of October in reply to our letter regarding the discharge of wastewater in Strangford Loch. Members, the response states that the Minister shares the concerns raised. His response details steps taken to improve water quality, including the publication of the Environmental Improvement Plan, otherwise known as EIP, and the third cycle River Basin Management Plan. In addition to, the Department has initiated the Wastewater Reform Programme with the aim of updating its regulatory process to align environmental reporting of wastewater treatments and networks in Northern Ireland with the rest of the United Kingdom. Have you any comments? Are you content to forward the response to the individual? Content? Thank you, members. Yep. Members, I refer you to table paper starting page 23 for a response from the department dated 7th of October in reply to our letter regarding the review of the NIEA odour guidance. Members, following our discussions on the 18th of September relating to waste and odour complaints, we requested further information on NIEA target number 12, which includes contributing to the development of odour guidance with a target date of the 31st of March 2026. The response states that the UK Environment Agency is currently carrying out a review of the H4 odour management guidance. Once the guidance is published early next year, NIEA will review it along with the Scottish Environment Protection Agency's Odour Guidance 2025 and Ireland's Environmental Protection Agency's Air Guidance Note 5 to ensure that NIEA continues to use best practice when carrying out odour impact assessments. Any comments you content to note?
No.
Okay, members. Item number 5, you recall at our meeting on 3rd July we noted the raised paper we commissioned titled US Trade Tariff Key Changes and Initial Considerations for Northern Ireland. It set out a timeline of key changes, actual and proposed to American trade tariff policy, and highlighted potential impacts arising for Northern Ireland. We then agreed to revisit this matter after summer recess, And since that briefing, the EU has signed a non-legally binding political agreement with the US, and the UK has also signed a technology agreement. Is this a matter you wish to look into in the future, and do you wish to seek a further update from RAIS? I am particularly interested in this because we are in a unique position in Northern Ireland when it comes to tariffs, and there is a technicality that I don't think anybody's fully bottomed out. Are members content that we do look to get a further update from RAIS in regard to the changes? Yep, thank you members, appreciate that. Okay members, agenda item 6 is the Dilapidation Bill oral briefing from the legal advisor to the examiner of statutory rules. Members, as would be usual when taking legal advice, I would now ask your permission that we go into a closed session with Catriona Doherty, BL, legal advisor for the Office of the Examiner of Statutory Rules, before moving back into public session on to continue our scrutiny of the Dilapidation Bill. Is that okay members? Yeah. Okay, thank you.
Members, we're moving on now to agenda item 7, Dilapidation Bill, evidence section, Department of Communities, Historical Environment Division. I refer you to pages 43 to 44 of the table papers for the briefing paper. For reference, I also refer to the pack for the Bill and Explanatory and Financial Memorandum, started at page 35, and the raised paper starting at page 75. Members, I welcome the following HED official to brief the committee and any questions. Manus Deery, who is the acting director. So, Manus, if you want to kick off there, brief members on some questions.
Okay, thank you very much, Chair, and thank you, Committee, for your invitation here to us to come and talk to you today about the Dilapidation Bill. I've got a short statement here which I'll just read through and then take questions. So, historic environment includes all aspects of our environment resulting from the interaction between people and place over time. The Historic Environment Division records, protects, conserves and promotes Northern Ireland's historic environment. Our aim is to help communities enjoy and realise the value of our historic environment. So there are just over 9,000 buildings listed as listed buildings in Northern Ireland and 2,000 monuments protected as scheduled historic monuments. Almost 10% of Northern Ireland's listed buildings are on our Heritage at Risk register. This means that we are concerned that they may be at risk of loss. This may be because they are vacant and vulnerable, but in most cases it's also because they're in poor condition. Because it's an offence under Section 85 of the Planning Act 2011 to demolish or alter the character of a listed building without consent from a planning authority, and also an offence under Article 4 of the Historic Monuments and Archaeological Objects Order 1995 to demolish a scheduled monument, the number of demolitions of listed buildings and scheduled monuments in Northern Ireland each year is very low. However, on occasion, the issue of a dilapidation notice under the current legislation has resulted in the demolition of a listed building without the required listed building consent. This is because such a notice currently says that an owner must take down, secure or repair, and makes no reference to the need to obtain any other permissions. So councils aren't allowed to choose between those three words. They have to put those three words in the current legislation. It also gives councils no scope to seek repairs without demolition. So while it's an offence to demolish a listed building without consent, no prosecution has been taken against an owner who demolished a listed building in response to a dilapidation notice. Presumably this is because it's not clear which legislative provision takes precedence or prominence. The division has worked with colleagues in DAERA since this bill was initiated, and we're supportive of the bill as proposed. It addresses our two main concerns by allowing councils to issue notices where it does not consider demolition necessary to carry out the work specified in the notice, and it also clearly states that nothing in this section exempts an interested person from the obligation to comply with any other statutory provision relating to the condition of the building. However, Section 85 of the Planning Act that requires listed building consent for alterations and demolitions does not strictly relate to condition. It relates to architectural or historic character. So while the intention of the proposed legislation appears to be clear, there may be an opportunity to strengthen the drafting in the Dilapidation Bill by revisiting the reference to condition in clause 4 brackets 5. We understand that the word condition needs to be inserted because if the reference was removed, then an interested person would be obliged to comply with all statutory provisions in relation to the building, which may not be the policy intention. For example, if a building is in a state of disrepair, it may not be possible to comply with all health and safety requirements. It might therefore be better to be explicit in clause 4.5 to say that nothing in this section exempts an interested person from the obligation to comply with any other statutory provision relating to the condition of the building or from statutory heritage controls relating to listed buildings, conservation areas and scheduled monuments. Or potentially it could be summarised as nothing in this section exempts an interested person from the obligation to comply with any other statutory provision relating to the condition or protection of the building. And that protection could then maybe be clarified in later notes. The division would also like to express its support for the provision in the bill to have a series of tools available to councils to tackle this issue. We feel that this will allow scope for use and familiarity with the legislation and help ensure that this becomes an effective way of tackling dilapidation across Northern Ireland.
Thank you, Manus, for that briefing. Manus, you said in your briefing there that your main concern is that we should take the opportunity to strengthen the drafting in clause 4 or 5, be revisiting the reference to condition, and you propose a form of words for such an amendment. Have you any view on why that more specific reference is not currently in the bill?
I don't. It reads, when you read through it, I suppose from our point of view, we were very happy to see this provision in the bill because previously there was this issue where it wasn't clear which legislation took precedence. Now there's a provision in the bill which says if there are other requirements that you need to have legislatively, you're not exempted from that by receiving a dilapidation notice. So that's very, very positive. It's almost a very minor point in terms of the word condition and how you would interpret it. My worry is would some party need try to exploit that as a loophole, maybe in legal terms, if they went ahead with the demolition? So I think that the intention in the drafting seems clear. That when you think about when you're drafting this, you're trying to say, look, we're talking about the big stuff like listed building consent. We're not talking about dealing with health and safety, internal health and safety concerns. So what's the word that you used to do that? So I think that's the decision around it. So I suppose, in earlier praises we've read that through and we haven't thought of it as a potential issue. But reading it through again, we're thinking, well, perhaps we should just bring this to your attention. But I would say it's a relatively minor issue relative to the overall bill, and we're very supportive of the overall bill, both in terms of the gradation that it has, and also in terms of allowing that split between take down and make good, and allowing people to have a dilapidation report just for repairs.
And I suppose just out of curiosity, do you have any insight as to the reason why this bill has been brought forward by this department as opposed to the Department of Communities, your own department?
Do. This bill is an action point arising from the Heritage Crime Summit that was called by the Minister of the Environment in 2011. So in 2011, there were 9 fires at listed buildings over a 3-month period. That was really as a result of the economic downturn where developers were pulling off security on sites. So there was a big fire at Sion Mills, there was a fire at Hilden Mill. The Minister took action and pulled together a Heritage Crime Summit at short notice. That brought all interested parties around the table, councils, departments, planning, to say, right, how do we tackle this issue? So the key thing that came out of that was the Minister gave us, as the division, money to issue urgent works notices, which we did, and that kind of sent out a message across Northern Ireland that the department was serious. But one of the other actions that emerged from that discussion was that the current legislation for dilapidations dated from the 1850s and 1870s and was very much out of date and varied between Belfast and other councils. And so there was an action point emerging from the summit, which was to develop new dilapidation legislation. At the time, we as the Historic Environment Division were a part of the Northern Ireland Environment Agency. So we were a division within the Northern Ireland Environment Agency. There was the Environmental Policy Group, where the group that developed legislative proposals within the Northern Ireland Environment Agency, and they were tasked with pushing that forward, which they did. In the split between the departments in 2015, we went to DFC, NIEA went to DAERA, but the legislative provision of what was NIEA went to DAERA. So that's why it is carried through with yourselves. Or at least that is my understanding.
So it goes back to the Heritage Crime Summit 2011.
It goes back to the Heritage
Before
Crime
the
Summit 2011. Yeah.
Departments were.
Yeah.
You look around, Daniel?
Yeah. Manus, thanks very much for being with us. I just received a letter there from yourself, just literally as you walked through the door, so that was good delivery. Why is it taken from 2011 to get to this point where we are today with this legislation? What's been the core reasons for such a delay when there was so much identified at risk 14 years ago?
Yeah, I can't really answer that question in any great depth. I know that there was a public consultation on it. I know that the kind of the bare bones of the bill have been drafted for a long time. My received impression is it's been the various collapses and rebuilds of the Assembly and just a time to get it through the system. But I don't know the real reason behind it. I can't really comment on that.
It just points to a lack of seriousness, in my opinion, when it comes to the built heritage across Northern Ireland. Like even in my own constituency, there's been a significant, and Declan shares the constituency, a number of historical buildings of significant historical value that have been destroyed, more so in recent years as the Assembly sat. Milltown House is up in fire, which you've written to me about, which was the home of Cecil Francis Alexander, a world-renowned name, and I don't believe enough has been done by the HED in relation to it. So for me, this bill needs to have teeth, very sharp teeth, given the history that's there. But how can we have any faith in the HED, for instance, if you continue to have a huge amount of issues around lack of resourcing, lack of funding? So what's the challenges that you face? Because it's okay bringing forward legislation, but if you have no teeth, no funding, no resourcing, how are we going to implement or deal with any of these issues?
Well, I think that's a very good question and detailed question. I suppose the focusing on this bill in the first place, this is giving, in my view, giving district councils teeth that they didn't have before to respond to this issue. We have our architects, our area architects across Northern Ireland, who are happy to engage with councils and owners. The issue of heritage risk in general is something that I referred to earlier on. It has dramatically increased since 2019. It's more than doubled since 2019. So there is an issue there in terms of what we do and how we do it. At present, we've carried out research into the condition of listed buildings in Northern Ireland, which shows that they've significantly declined over the last 20 years by almost 25%. Mm-hmm. We have also published research into market failure and heritage in Northern Ireland. So trying to understand from owners why why the investment is not being made that needs to be made in these buildings. Both of those pieces of research are informing a business case that we're currently looking at, which is arguing for increased research to invest in supporting owners, but also trying to be creative about how we support owners. So addressing the barriers that owners face in terms of advice, in terms of access to skilled tradesmen, and in terms of giving them the confidence to know that they can and they should invest. One of the interesting things that emerged from that research is there's a direct correlation between owners that place value on their buildings and their condition and their state of repair. And that's not just economic value. So if you've got a shopkeeper who has to have a listed building to work in, they value it to a certain extent. But if that shopkeeper values it as a contribution to the town and to our wider heritage, it's much more likely to be in better condition. So there's an amount of work to be done with public and owners about increasing our awareness and appreciation of what we have. And there's an amount of work to be done with public representatives and the wider community in terms of the wider benefit that heritage brings to Northern Ireland society and how we can contribute to the aims of the programme for government. So all of those things are important if we're to raise the votes on that.
They're absolutely important, but there's very little new in what you've said, Manus. The problems that you've articulated to this committee are not new problems. They've been the core reason for the significant and mass deterioration of built heritage across Northern Ireland over a number of decades now, but particularly in more recent times. It is a point of great frustration for me, given that you are so badly resourced. You know, there isn't sufficient staffing, capital budgets. You know, you can't keep up with the pace of the challenges that are faced there, and there's not going to be. Councils are struggling. You know, so saying that this is going to give some teeth to the council is really, I don't believe, accurate, Chair, for a very simple reason. There's no extra resources coming with this for the council to actually proceed with any form of enforcement or material action. The other thing I would say is it's not just individual owners, Manus, private owners that are responsible for the deterioration of built heritage. You know, departments and public-owned properties of significant value have been just left in a very terrible, unacceptable state, and a law unto themselves, really, and Milltown House is an example of that. But equally, financial institutions such as banks, following the repossession of businesses and historical buildings, have also seen significant deterioration. Say in Mills, which you've referenced, a lot of the deterioration of that mill, which was in pristine condition in 2011, happened as a result of the bank just basically getting away with what they were doing. So my concern about all of this is legislation is great, but if there's no resources to back this up, it becomes nothing more than unenforceable. And the very fact that, given the amount of damage that's been done to built heritage deliberately in a lot of instances, and there's really been no prosecution taken, speaks volumes to how the department has utterly failed to protect our built heritage. And I'm asking really what you think the HED needs to ensure that they can guide the council in the important role and function they're going to have as a result of this legislation. But what action's been taken to point to the Minister and say, show me the money, Minister, because this is really not going to do or deliver anything without a single pound behind it.
If I could just, there's a lot there, but I suppose the one thing that I would cite as an example is that in 2015, in the planning legislation, there is what is called the opportunity to issue an urgent works notice. So that is that the planning authority can say that a building is in a state of concern and can issue a notice that says that an owner should fix up or carry out the minimum works, or else the department or the planning authority will go in and carry out that work. Now, following the Heritage Crime Summits in 2011, we got money from the Minister at the time. We issued 6 urgent works notices across Northern Ireland, and we made sure that they were in different parts of Northern Ireland so that the message went out that we were serious. That response, the second year we did that, we issued 6 urgent works notices again, and only and out of those 6 notices that were issued, 5 of them were carried out by the developers themselves at no cost to the department. So the message had got out loud and clear that we were serious and the work could be carried out. That power has subsequently been devolved to planning authorities within district councils. If you imagine yourself as a professional planner, you're not an architect like I am and my team are. You've got no background in what a notice like that should be. It's an uphill road for you to carry out and serve that. This legislation is going to be sitting with the building control officers in councils. Building control officers are construction professionals. That is their bread and butter. I would be hopeful that this legislation will allow that action to take place that hasn't necessarily happened through the devolution of that power into the planning authority, because it will be the people within councils who have that knowledge who will be taking it forward. So yes, there's an issue with funding. Of course there's an issue with funding. You know, we invested £32 million in grant aid between 2004 and 2014 as HED. We invested £2 million in grant aid between 2014 and 2024. It's a dramatic change, but we all know that there have been significant cuts across, and we've tried to kind of work with that. But my hope would be that that this legislation will be more effective because of that. The other thing I would say is we don't exist in a bubble in that the economy is hugely important. There's a direct correlation between heritage at risk and economic. So if you look across the UK, unsurprisingly, southeast of England, there's not very much heritage at risk. We're in a poorer part of the UK. We don't have the same monies. Galgorm Castle has got a trust now looking at its future. 15 years ago, I was walking around with looking at that and looking at potential for maybe enabling development with a colleague from Historic England, and he was saying, if this was an England Manus footballer would have bought this, you wouldn't have the problem that you have. So our economics, you know, we as the department can help support that, but there are wider issues at play as well in terms of finding sustainable uses for these buildings. But we could always benefit from more money.
Just a final point, Chair. You've referenced the urgent works notices. Have you the figures for how many has been issued by each of the 11 councils?
I don't have those figures to hand. My understanding is that there have been a few have been issued, I think by Belfast, but generally not very many. So
you'd agree, Manus, that doesn't really reflect the story on the ground then? If only a few have been actually enforced or issued, then really the council, even at this time with the power that they currently have, are not taking the necessary action.
Yeah, like there are resources associated with that, so we all know the sort of situation that councils find themselves in. But I suppose what I'm saying is, while you have a similar situation here, I would be more optimistic that you've got a bill which is a gradated approach, which means that staff will become familiar with the legislation, used to using it, and therefore more inclined to use it if needed. Whereas at present there's legislation in a separate thing organised and people aren't familiar with that, and so therefore it's almost a higher test to encourage people to use it. So my hope would be that this will be a positive.
Okay, thank you.
Thank you, Daniel. I'm sorry, Manus, just a few of us had another engagement. You are the man that I want to speak to, however. Okay. And please excuse me if you can't answer this question. I don't mind. But I was quite excited about this legislation coming forward, but I'm less than excited now.
Right.
And the reason I'm less than excited, I'm going to paint a picture for you, and if you don't want to speak on the specifics, that's quite all right. So from my assessment of it at the moment is that it's a piece of legislation which is being brought forward to bring together other disparate pieces of legislation to make it easier to interpret the powers that already exist. It doesn't look to me that there's any ambition to enhance the powers, particularly around council, because the very first provision of the bill says that council may, in regard to every aspect of this bill. So if I look at something specifically in my own constituency, which is Hilden Mill, which is a significant building, and I'm sure you're aware of it. It has historical context. I believe it's either a listed building or something of that space. And given that Linden was one of the three pillars that held this whole island at one stage, and something I'm very proud of, is something from there. There, as the last member said, there's fires in it multiple times per year, and it's in a dangerous provision. What I had hoped for in this legislation, that it would give some teeth to councils, perhaps working with ourselves to revive our space. But looking at it, I don't think it does anything in that space at all. Is there any confidence that you can give me that this legislation does, in fact, engage those teeth that councils?
What teeth do you have in mind?
Well, so and I think Daniel touched on it, because if the areas of dilapidation that we see which make the greatest impact are probably those of historical context, and setting aside our main streets, obviously. But people own them, people buy them, property companies buy them to speculate and to change probably the nature, not to change the nature of the place, but inevitably that's what happens. But in terms of that historic value, which none of us want to see lost, we've lost too much as it is. The teeth that would enable a council to work, for instance, with a planner or a developer, not to see a site redundant or banked or left open to what cannot be spontaneous combustion on that site because there's no electric. So obviously fires happen, and then there's a danger to young people and those people that enter it. So to move something like that into a phase where, in cooperation, but with the teeth of council and legislation, that in that community they will see that restoration and that value appear again. I don't think that the legislation leans into that space at all.
I think the legislation is reactive, isn't it? It's about dilapidation. It's about saying, if there's a problem, here's what we're going to do. We're going to try and encourage you forward, and there are various levels of stricture around that. I think what you're talking about is about a community coming together to try and find a way forward. And certainly, we have examples of communities doing that very effectively. And almost the assuring long-term sustainability. If a community is involved, it's very much part of that, and that's very positive. I suppose really I wonder whether this is the legislation for that. This is about a very kind of a practical thing of building control officers responding to problems and dealing with problems and trying to push them forward.
What I would say, Manus, is that the problems exist in community, so that they're not in isolation, and there is no other legislation that I'm aware of that could or is even muted to pick up the physical danger, the loss of amenity, which is an issue in community. And in fact, I'd go as far as to say it has a detrimental effect on property value. I think when we go around areas, any built area, the better an area is kept, I think the happier the people are as well. So it has that consequential impact as well. And I'm not aware, and this is where I'm thinking that for me it looked like there potentially was an opportunity. And I'm not clever enough to have the exact answer to what that might look like, because I understand it's fiscally difficult.
Yeah, I would agree with you strongly that they talk about the broken window theory, that if a window is broken and left untended, that then things can go, so it's kind of like the BT phone boxes where they were quickly responded to and there was an issue addressed. If you've got an area that, for example, we have a small grant scheme at present called the Village Catalyst programme, where we are working in partnership with DAERA through the DAERA TRIPSY scheme, tackling rural poverty and social isolation. And so what we've done is we've come together with the Architectural Heritage Fund to provide viability and development grants for communities and villages to take on heritage at risk within their village. And then the DAERA money then is providing the capital support for that change. It's a really good scheme because it's not just about fixing up the building, it's about making sure that there's a sustainable use that tackles rural poverty and social isolation in the building. So we've had 5 schemes done so far. Ederney jumps out at me, Ederney, Caledon, Gracehill, Culmore and Rathfriland. And in all of those villages you can see the change in the community, just people's smiles on their faces almost, but you can see small things. You can also see private developers going, things are changing and investing in the village in the way that they didn't. So public investment in tackling heritage at risk in the centre of the building really makes a big change and is very, very positive. So it's about kind of so whereas if you've got a building like that, like one of the places we're looking at for a scheme is Newton Butler, and Newton Butler, if you've been through it,
Name for a town.
you know, it looks very run down at present. You know, it's kind of looking forgotten about. You know, so the community is coming together to kind of do one of those schemes there, and you know that that's going to transform that place. So I agree with you fully that it's part of the addressing this issue, or an important part of addressing this issue, is about working with communities to get a way forward. One of the things that we are working on, actually our colleagues, the UAH, are here, who deal with heritage at risk, compile the heritage at risk register with us. And but we're looking at a heritage at risk policy, and you know, working out exactly what we can do and trying to be clearer for everybody what we're doing and why we're doing it, and how we can work together to make the most of the resources that we have to deliver.
Thank you, Manus. I appreciate that. Thank you. That's something I'll pour into a little bit more. I know Anya and then William. Anya.
Thank you, Chair. Thanks, Manus, for coming in. I am over the moon that you've referenced Newtown Butler. It's just the town over for myself, and I suppose it's probably one of the stark examples of how dilapidation can have an economic, kind of a serious economic impact on a small town and village, especially in a rural area. And I suppose from that, my question is quite broad, but in terms of this legislation, how do you practically see the legislation working alongside DFC's shape and sustainable places policy, and I suppose rural regeneration more so?
Well, the shape and sustainable places policy it's just been out for consultation, as we know, but the idea behind that really is that there are community plans for places that have been developed in partnership and are presented by councils, and that they form the framework for what happens in those places. It's going to be council-led. Council will also have these powers, both the planning powers and the dilapidation powers. So that potentially gives power to councils to seek to work with people, which is always the best way, but also to have that stick as well to say we can serve this power. So I think it will be a positive addition to the toolbox in terms of addressing those issues.
Thank you, Manus, for that. And just in terms of the briefing we had last week, and I know I had raised some concerns, as did others, around this bill being, or the draft bill at the minute being urban heavy and rural light. What would your reading of that be, or what would your take on that be?
Well, I think one of the positive things in this bill is, you know, there's been an assumption, or the existing legislation talks about dilapidation notice, health, it's about safety to the public, and really it's where a building is overhanging the footpath, it's a danger to the public and can be demolished. In the past, we've had buildings sitting in their own grounds, which are more likely in the rural area. Dilapidation notices can't be served on them because they're not a direct danger to the public. This legislation, in my reading, allows a dilapidation notice to be served on buildings like that. So while there'll probably be a period of time as council building officers get used to this extra potential, it does provide that potential to take action and not have to wait to the last minute when things are about to just collapse and hurt people.
Thank you,
Yeah.
Manus. Thank you, Jade.
Yeah. William?
Thank you. The dangers in this bill, I think it'll be fraught with legal difficulties, but I live near a local village, not a large village, now a small village, country village. There's an old house not lived in for 40 years, has been listed, tin roofed, never be lived in again, without massive spend. I'm told the only piece of the actual building that's listed is the porch. Does it make sense to do that and leave a dilapidated building that's not going to be replaced or lived in again?
Yeah, I hear you on that. I suppose the first thing is to say is it won't just be the porch that's listed. A building will be listed in its entirety. Perhaps the porch might be the most important part of the listing.
Well, if you've seen it, you just wonder why.
Yes.
I
suppose it's about looking at these things in context as well. You know, we've had a massive loss of our rural historic buildings over the last 20 years, and in terms of our thatch buildings, for example, only thatch. The only building, very few buildings are left that are thatched that are not listed. So there have been major economic changes in how we live, which has had that impact. But it's important that we have remnants of what our previous historic buildings or what our character was like. I don't know that particular building, and I don't know how bad or otherwise. I would be happy to send our area architect down to talk to the owner to see what potential might exist.
The owner is the church, actually owns the building, to my knowledge. The church still owns the building, but it's a tin roof building, it's an old building. There's been negotiations for repairing it, but the cost of repairing it you wouldn't know where to start and where to finish. It's not a historical building in the main. You know, I can understand listed buildings, but this just doesn't seem to
make sense. Yeah. No, I suppose there's a decision that the department has to take. You know, the buildings decay, and buildings are not listed on the basis of their condition. They're listed on their architectural and historic interest. We as the department don't want to be turning around and delisting buildings because they're in poor condition, because that would encourage people to, if they don't want them listed, to leave them so that they're not in poor condition. So we have a judgment call to make in these things. So our approach would be, if it's listed, to keep it on the list and work with owners to try and find a solution.
It's been idle for 40 years and no solution found. I can't see a solution found to this one.
It's so optimistic, William.
Thank you, Chair. How do you respond to the Ulster architectural heritage whenever they say that their fear and their concern is that this bill will facilitate further loss of historic buildings, which really is a matter of grave concern? I'm one of these people who feel that all our old buildings should remain, should that be an old school in the past or whatever, that all these things should remain and should be looked after and all of this type of thing. And you know, it really grieves me when somebody moves into an area, and, for example, an old school, and buys it and tosses it and puts a modern house on it. It destroys the whole area that has been in. Well, I'm talking about the rural areas, I suppose, more so than the urban areas. So, you know, how do you respond to the concerns that they have with regard to this bill?
Well, I suppose they're going to be talking later, so I don't have detail on why they're making that argument. As I perceive it, this is about providing councils with tools to take action. It's not about providing a charter for demolition. And so it seems to me that this is an extra tool which hopefully will allow councils to intervene before buildings come to a stage where they are lost through neglect. And that is a positive thing to my mind. I presume and I'm making presumptions here, which is not fair, but it might be associated with the sort of argument that Daniel McCrossan was making earlier on about wider funding for the historic environment and how people who owned buildings for 40 years that are in bad condition can be supported to find a sustainable use.
Okay, Chair.
Okay, any other questions, members? Manus? Okay. Manus, thank you very much
Thank you
for
very
your time
much.
today. I really do appreciate that. Thank you.
Agenda item 8.
Okay, members. And we're on agenda item 8, which is still a dilapidation bill, evidence session on from Ulster architectural heritage. So members, I refer you to pages 32 to 34 of the pack for the written submission providing their views on the bill. We welcome the following representatives from the Ulster architectural heritage to brief the committee and to answer any questions on their briefing. We have John Anderson, Chair of the Architecture, Planning and Policy Committee, and Scott McBurney, Member of the Architecture, Planning and Policy Committee. Are you content?
Thank you, Chair. Unfortunately, Mr McBurney is ill, but my colleague Sebastian Graham, who is the UAH Heritage at-Risk Officer, will also be available to ask questions.
Do you want to join it, Sebastian? Thank you. And you could be Scott for the day, or we'll remove Scott's name and we'll wish him all his best in his recovery. Thank you. Thank you, John. And whenever you're ready, just crack on.
Right you are. Thank you, Chair and members, for the opportunity to present. Ulster Architectural Heritage has been going since it was established in 1957. Our primary concern is obviously heritage buildings and the promotion of those buildings, the preservation of those buildings, and the sustainable reuse in the interests of communities, in the interests of economy, and so on and so forth. We publish, I suppose, the definitive set of books on Ulster's built heritage. We participate in consultations, we give lectures. Effectively, we're on the ground as far as planning in relation to councils and so on. So I'll not dwell too long on that. You've already a synopsis there. Personally, I'm an engineer, retired, long history of involvement with the Statutory Advisory Councils, with European affairs when pre-Brexit, member of the Ministerial Taskforce for Culture, Arts and Heritage, and currently member of the HED DFC Historic Environment Stakeholder Group. Manus will smile ruefully. We have a very good relationship with HED and have had over many years, but as an independent NGO, as I say, Manus will smile ruefully because on occasions we can say what we like, which he, because of restrictions, cannot. So, I'll just go to my cog notes here. We do have a big problem with this bill. We were consulted at a very early stage, and I spoke to the senior civil servant, whose name I can't remember, who was in charge of running this through. He wasn't really very clear as to why he was having to do this. We expressed the same concerns as we'll express today, maybe amplified today, but we had no further contact, and it doesn't look in the bill as if any of our concerns were really addressed. We believe that this introduces yet another element of a split responsibility. We're heavily involved with heritage planning, council planning committees, and the existing legislation in the 2011 Act, and also PPS 6 and its successors. We believe that all that legislation is adequate, but it isn't used. And it isn't used for, as Mr McCrossan said, there is neither the will nor the finance for councils to use it. We'll come to the will bit again. This is very much hooked in with planning and heritage planning. And you have DFI, who are supposed to oversee council planning. The 2-year assessment promised in 2015 with RPA has still to happen. So councils effectively have settled into what some might say bad habits. Then we have DFC HED, who admirably do their very best in relation to heritage buildings, and now we're introducing DAERA as well. And one of the questions I would have, I suppose, for the Minister is DAERA going to oversee and monitor this, or is it going to be done by somebody else? And looking at the plenary Hansard, it was raised by some members quite correctly. Why is this being put through in the absence of the guidance document? I mean, the two have to go together. Guidance document is very key. Now, guidance is all very well, but in our experience with council planning, quite often guidance, the members will say, well, guidance is guidance, it's only guidance, it's discretionary, and we can effectively decide and effectively ignore the guidance. In which case, why is the guidance there if it actually doesn't carry any weight? Just to jump back to UAH and guidance, a number of years ago we took 2 very onerous judicial reviews against the then DOE. That established the case law for demolition of an unlisted building in a conservation area. Now that case law is in the DFI guidance to councils in relation to demolition of an unlisted building in a conservation area. And there are a number of steps, very clear steps in the legislation that you have to go through. Councils routinely ignore that. We can howl at the moon as much as we like, but councils are ignoring guidance. So that is an issue in itself. Duplication of powers. We believe, and I think in your synopsis there'll be a list of powers that are within the 2011 Act. Now, those are in regard of heritage buildings. But we believe that this bill will substantially target heritage buildings. It is mostly heritage buildings which are derelict, in a lot of cases through land banking. Modern dereliction, we believe, is a different thing. Say you have a 1970s, 1980s terrace building which has broken windows, or there's been a fire, or there's been some intimidation issue or whatever. That doesn't really need this bill because it can be dealt with building control, environmental health, and if necessary the police. So we believe that what this bill will target is heritage buildings. Now, in the absence of funding, and the Minister has admitted there is no funding, and the fact that it is discretionary, and we now turn to the 4 categories of ownership, I think, in our submission to you. First will be land bank by speculators. And this isn't being dealt with and hasn't been dealt with because, and I'm talking generally here, with many of these buildings, a speculator will buy a listed building or a heritage building on the basis of, first of all, it was cheap. It will sit quite often on what could be perceived as a valuable site. Hilton Mill would be an example. And there is no incentive to maintain that building. And in fact, there is an incentive not to maintain it because a big listed building like Hilton, the developer will be availing of a 0 rate because it's an empty listed building. Now, for a building the size of Hilton, I imagine that will work some hundreds of thousands perhaps. You then come to the fact, is the building insured? Because if the developer is having a nominal hundreds of thousands bonus, and given that Hilton was in good condition when it was bought, why isn't the building insured, and why isn't that benefit tied to having insurance? Now that is a thing which this bill doesn't deal with and could have dealt with. And we've said this to Land Property Services. The process, and I have to declare an interest here because myself and my wife are working at a little 1740s building in the North Coast, and our rates would be $4,500 a year because part of it was once a shop. But our insurance for that building is £450. So you can see the balance. Now, some of these buildings won't be insurable, and that generally is because they've been neglected for so long. Well, that generally is down to the land banker. The second category will be owners who own a building but don't care about it. They have no love for the building, they have no wish to spend any money, and there's no profit motive in that. They just don't care about the building. Third category will be, like ourselves, people who care about a building, want to see it restored, and either haven't enough money to do it at a jump, or aren't physically able to do the work themselves. Not us. We dig and pick and so on and so forth. And then the fourth category is public ownership, like the one at the bottom of your garden here, Dundonald House. And with those three categories, to avoid legal, to avoid hassle, to make a problem disappear quickly, the best option is demolition. And we are losing national heritage, because this is a national asset. We're losing this year on year on year. And councils, and indeed this building, doesn't look on it as a national asset. It looks on it piecemeal. It's a building here and a building there. There's no sense of cumulative loss. And it may seem rude to say it in this building, but at least part of that, maybe a major part, is actually the fault of this building. Because there doesn't appear, nothing happens here, nothing happens anywhere without political will. And I think 3 iterations ago, the PFG had a section in it to do with heritage. That has now been removed. And this is the Republic's 30-year, 2030 plan for heritage. All the parties in the Republic are signed up to this. We are probably where the Republic was 30 years ago, 35 years ago, in the demolition phase. The Republic have woken up to the fact that this is a national asset. It's as much of a national asset as natural environment and all the rest. It's a tourism asset, it's an economic asset, it's a feel-good asset, if you like. The budget was announced yesterday in the Republic, and the budget for this from the Department of Housing, Local Government and Heritage for 25-26 is €235 million. Now, we cannot hope to mimic that, obviously not. But our problem is not a health or an education level problem. What we need is a sustainable year-on-year few millions. And that, if it's employed properly, can make an enormous difference. Looking at the plenary, the Minister, I suppose, praised the scheme of a number of years ago from DOE. We call it the vinyl scheme, where buildings were clad to make it look as if they were occupied or in good condition. Now that scheme was £8 million. And what it did was it covered buildings in impermeable plastic, and they rotted away in behind the camouflage. Effectively, these were Potemkin buildings, made to look good, but actually speeding their demise towards dereliction. Buildings like that in council committees, and indeed in the Hansard plenary, and again mentioned in our summary, emotive language, eyesore, social misbehaviour, environmental health, those are used regularly in councils, and they were used in the plenary by members. That's what destroys buildings, because that emotive language is what gets into the press. The public will look and see that. They don't see the benefit of listed heritage buildings because they're not led to see it. And again, that comes back to political will. I've probably said enough. I'll just... a couple of examples. Mr. Crossan mentioned the house in Strabane,
Milltown House.
Milltown House, Strabane Grammar. That was a house, presumably, when the Grammar moved, was in pretty good condition. Certainly, even after the fire, the exterior looks as if it has been in good condition. Was the building insured? And if not, why not? I mean, I don't know what way... I know government insurance is a sort of block, so there isn't specific insurance, but the insurance is there if it's needed. Whether that applies to education authorities, health authorities, I don't know. I would imagine it does. And if there is insurance, and there were two examples in Belfast, Primark, burnt to the ground. Cathedral buildings opposite the cathedral, also burnt to the ground. Both those buildings are now restored, and they're restored, apart from the fact that their owners wanted them restored, they're restored because they were insured. In the case of Primark, 7 insurance companies and 100 million, unbelievable. But the insurance was there, and the building is now restored, and a credit to the city. The insurance issue in relation to publicly owned or publicly related owned buildings, that insurance question needs to be answered. Another example, and again, we feel mirrors what this bill will actually produce or not produce. The Antrim Arms Hotel in the centre of Ballycastle, owned for a long time by developer, speculator, neglected, and for a long time there has been a problem with the main gable, and that problem has now been highlighted and appears to be getting worse. The council, without putting too fine a point on it, faffed about, and the developer went to court, and this is another issue with courts being involved, especially magistrates' courts, because generally speaking, with the best will in the world, local magistrates don't have much of a clue about heritage buildings. So it went to court. The council should have served an urgent works notice on the building, because what effectively it needed was propped, which is a fairly simple operation and wouldn't have been that expensive. The developer went to court and basically has said the building is listed, it's in a conservation area. Ballycastle is possibly our best preserved seaside town. The developer has been quite blatant. He says he wants to build a boutique hotel on a clear site. So the council basically retired with its tail between its legs, paid with public money to put containers and barriers around the end of the building, and the whole process is now stalled. because the court judgment effectively scared the council off. Nobody knows what to do. Actually, what to do is the council, I gather, and it's very hard to get information, never actually served an urgent works notice as they have powers to do under the 2011 Act. So our worry would be that this bill will effectively produce lots of situations like that, and always the easiest way for all parties and the best way for a developer is demolition, and demolition as quickly as possible, which delivers a clear site. And indeed, some of what the Minister said and some of what is in the financial justification for this bill actually mirrors that. It says it will serve property developers to increase site values, to give construction jobs, and so on and so forth. So it is geared the wrong way in the first place. And I should probably stop.
Really appreciate that. That's very, very good. And thank you for the paper. And I'm evidently very passionate about this, and certainly in the same space, I think, as myself and a couple of other members. There's one thing, I don't take issue with you saying this because I understand where you're coming from, but it would indicate that it's probably useful too in terms of when something like Hilton Mill in the amenity, it evidently is an eyesore, and so I don't think they're unfair, but I do take your point and I agree with you. There's also the other part of that language has to come and say, but this is incredibly valuable to this, and it is a beautiful building, and it could be once more. And I think it's that.
There are examples. Yes. I mean, if you look at Salt's Mill in Saltaire outside Bradford.
Yes.
If you look at the name escapes me, the one in Scotland.
New Lanark, sir?
New Lanark in Scotland. Magnificent mill buildings in everyday use. Just a couple of stats in relation to Sebastian, much more over the stats than I will. In England and Wales currently, there are 60,000 thatched buildings, most of which are in everyday use. And if you go to England and Wales, you will see in small settlements all over England and Wales, you will see very attractive thatched buildings. In the 1950s, we had 1,500 surviving thatched buildings. We now have less than 70, and they're not all in pristine condition, and they would fall under the category dilapidated. So are therefore serious.
Probably singularly most evidenced in our attitude towards thatched, I think. There's significant failures here over them. I've just got one question, and I'm going to go to the chair. And guys, if you could keep this to one question, if you don't mind, as best as possible, because we've literally 3 more briefings to get through, and I don't want you walking out on my head at any stage. Your paper states that the councils are empowered at present to compile lists of unlisted heritage buildings, which are of local importance, many of which are in the owner categories that you've put out. A lot of them are dilapidated due to the absence of monitoring and enforcement by those same councils, I would agree. You say there is no evidence that councils do this to any meaningful extent, but could you give us any report back from any engagement that you've had with the councils over the years to try and get them to compile such lists, which would help us evidence and monitor that and manage that?
We have success with councils in areas, I suppose, which could be described as safe. We do get the impression that some councils don't actually want this information because it would imply that they have to do something. And I mean, we, as an organisation, we could quite easily do this for all the councils if we were asked. And we could probably do it much more economically than it could be done in-house, if you like. I'll give you an example. One of the London boroughs, what they do with a very small team, 2 people, and it's a big borough with lots of conservation areas. What they do is they photograph all the buildings in the conservation area, the parts that can be seen from the street, once every 2 years. And then they compare those photographs with the previous 2 years. And if an owner has done an unauthorised alteration, he's invited to apply for planning permission. If he doesn't get planning permission, well, then enforcement kicks in. It's a very simple system. It's very easily worked. And once owners incidentally get once a year a very cheap little booklet tell them about their conservation areas. It's a mindset. Owners get the mindset, and they also start to take a pride in their areas, and neighbours will almost self-enforce. But there isn't anything like that. There is no, or very little local mindset along those lines, and that's because, again, to jump back to yourselves, there is no political mindset. There is no political will to do this. Individually, I have no doubt, and indeed I know, individual members do have the will to do this, but up to ministerial level. And I hesitate to get political, because we're not political. We're a 9-county organisation, always have been, but we're completely apolitical. But Sinn Féin, and we have said this to Liz Kimmins, we've said this to other senior Sinn Féin people, Sinn Féin are signed up to this policy in the Republic. And our view on built heritage, most of which is pre-partition, is that it's both Irish and British. Sinn Féin are signed up to this in the Republic, and they have the potential to lead this up here. But there is no sign of that, and we can't really quite understand that. That's not to get at that particular party, because anybody can start this. Anybody can start this process. Any of the parties can start this. Yeah. But it's just they already have a handle on it, so to speak. So yeah,
it is a complex issue. There's no doubt. Just thinking in terms of that example you give of the derelict properties, it happens in residential too. Because I have people now reaching to me who live in either private properties or sometimes even housing executive-owned properties, where the state of disrepair to an empty or vacant property is such to the fact that they lose their own amenity. I mean, it's a wide-ranging one. Okay, thank you very much for that. Declan, you're first.
Yeah, Chair. Just going by your briefing note, John, and your comments there. Are you effectively is the view of your group that we shouldn't proceed with this bill, but rather we should upgrade PPS 6?
Possibly, I'll send the committee our response to the sustainable communities thing as well, just as a bit of background. We believe that the root of this lies in planning, in the education of council planning committees in relation to heritage. I mean, quite often, I was a albeit independent councillor for myself for a number of years, so I've seen it from both sides of the table. And many councillors on planning committees, there's too much rotation in planning committees as well, because nobody, across the water, a planning committee chair, for instance, will basically learn the legislation, and assuming he can stay elected, he'll be there for 10 years or more. So he is there as an expert to guide his committee. That doesn't seem to happen here because there's really quick rotation all the time. I don't really know why. But again, you've 11 different councils here. You potentially 11 different LDPs. You've 11 different interpretations by officers and councillors who aren't sufficiently trained in heritage. And there is no national policy to protect national built heritage asset. Now, PPS 6 is good. It wasn't always adhered to, but it's a good piece of policy. It needs tweaked a little bit, but I hope Liz Kimmins' review of planning, and we've talked to them, and we talked to Rosemary Daly in DFI about this, and we hope that if the Assembly is amenable, that will be talked about at least. I mean, we have no clout other than our experience, if you like, but we've been there and done that, and we've been there and been doing that for many, many years. So we've seen the progression of loss, and since RPA it has got worse. The last audit report on built heritage protection in Northern Ireland was 2012, and I think the DOE committee then produced their own report also in 2012, and the reports basically confirmed the abysmal state of built heritage protection in Northern Ireland. Now that's as long ago as it is. This winter, we're going to the auditor again and asking that they do a new report on this. And we'll basically say to them more or less the same as what we're saying to you. But again, Stormont can lead this.
I think it's an interesting point because, sorry, Declan, just on the PPS, I think the different interpretations of the planning policies across the councils is indicative of my fear with this bill, that the attitude to risk, because it's a May and so on, we're going to get a doubling down of some councils performing ambitiously and some not.
The LDPs are fine, absolutely. I mean, only an LDP can deal with local issues. But, as I say, coming back to the point, built heritage is a national asset, and it needs a national policy in the way that's in the Republic, in the way that it's in. Dare I mention France, given what's going on at the moment. The French have a word for it, and it's nothing to do with flags or patriotism per se, patrimony. And that takes in built heritage, it takes in food, it takes in wine, it takes in their engineering skills. We sort of lack that. As I say, everything is taken piecemeal. Oh, there's that building. Sure, it's derelict. Well, no, that's all right. Sure, knock it down, and there'll be a modern building put in the space. The modern building is boring. It has no. Most new buildings in Northern Ireland.
A lot of members might be architects who might be offended at that.
Most new buildings in Northern Ireland will never be listed, because they're boring and they have no architectural merit. They're basically just boxes of square footage. Whereas the real character, the real interest, you go to France, you go to Spain, you go to Germany, everywhere you will see heritage buildings, everywhere. And people live in them on a day-to-day basis, quite happy. Yeah. Here, there is a tendency to the McMansion, built out in the country, ostentatious, eagles on the gate, completely out of character, despite the fact of decades of really good documents, rural design guides, so on and so forth, which are sitting on shelves gathering dust.
Declan, have you any more on that one?
No, my supplementary was answered.
All right, brilliant. Daniel, now behave now because it's 12 o'clock and we've like.
I would never challenge the chair, but you did squeeze in 4 questions there, but we'll not argue over it.
Down to one.
That's all right.
Down to one.
John, very good to see you. Thanks for your presentation. You've obviously got a heartfelt and determined passion for heritage. I've said to our colleague there previously about the challenges that we're facing: under-resourcing, limited capacity, weak enforcement powers, slower, more bureaucratic processes, particularly in Northern Ireland when you look at other jurisdictions. And also, interestingly, I was looking at the figures, lower economic leverage of heritage. It was referenced in the BHARNI report, and it said that the economic contribution per capita of heritage in Northern Ireland was estimated at £160 per capita, compared to £491 in the south and £943 in Scotland. So there's a massive disparity, and that really speaks to how we see and how we value our built heritage. You pointed to a very important thing: the failure of this place to centralise this issue, take hold of it, and to lead and run with it. And I think there's a number of strains for that. So I have 2 questions in one. What's your view of the lack of prosecution in relation to the deliberate damage and destruction of built heritage in Northern Ireland? No prosecutions.
That's
well, and the second wee point, just because he'll intervene. The second wee point, very quickly, is
he's not getting the second go, John.
The second point is, what do you see as the immediate solution to this problem to ensure that we don't see the further demise of built heritage across Northern Ireland? And do you feel that our historical or history in this place, particularly since the Troubles, has led us to value less our built heritage because we had so much destroyed by bombs during the Troubles, for instance?
I think that's often used as an excuse, and it's overused. to answer your second part first in 2 words, 3 words: political will and a small amount of multi-annual funding, which doesn't have to be begged for by ourselves and the department every year. I can't remember what the first question was.
Prosecutions.
What's your
view of them being so low?
Prosecutions is entirely to do with, again, the will within councils, or indeed the department. Well, no, the department have the will, because there have been a few successful prosecutions recently to do with monuments. The fines, on the other hand, there's an element of educating the judiciary here as well, in the fact that it is a national asset. So it's basically down again to money and will within the council officers, really. And just on Milltown House, with buildings like that, especially publicly owned buildings or related publicly owned buildings, across the water it is quite often when a building like that becomes unused, there's a guardian put into it, effectively a live-in caretaker, indeed sometimes with a family. And that can be done very economically, and it means that it's a bit like if you abandon your house, somebody will vandalise it. But if there's somebody living in your house, it's pretty easy to say that it won't be vandalised, because effectively there's a guardian there all the time. This can be done very economically. It's done as a matter of course. I think it's even inserted in some legislation across the water. So it's an easy fix, but you need a building in good order to start with. And many of the buildings that are now seriously dilapidated were in good order to start with. Crumlin Road Jail or Crumlin Courthouse being an example.
Thank you. Okay, thank you. Members, any other questions? Thank you. That's well done today, Daniel. More of that. There's an opportunity there. I mean, you can keep in contact with the committee, and as the bill develops, we will be considering all the clauses and potential amendments ourselves too. So some of the stuff you spoke about chimed with some of the stuff that was spoken in plenary, as you said. So please do feel free to continue to communicate with us. And if there are clauses in particular you think that could be sharpened up, or you have any concerns with, communicate that to us. It helps us in our due diligence and our scrutiny of the bill. And I want to thank you for your time here today. It was
thank you for the opportunity.
Thank you very much.
Well, I wasn't too long-winded.
No, you did well. It's good to see. It's good to see passion. It is. Agenda 9, members, is the Departmental Oral Evidence Session, Marine Licensing Clause 16 in the Administrative and Financial Provisions Bill. So members are referred to the pack for the following papers. The Department's briefing paper starting at page 135, the bill and the EFM starting at page 139, the raised bill paper outlining key considerations starting at page 175, and a letter at page 46 of the table papers that we were copied into this week from the Delegated Community Development Association to the Minister requesting an amendment to the Marine Licensing Exempted Activities Order No. 9 2011 to allow for a narrow exemption for temporary low-impact community-based events held on the foreshore. If anyone has any queries about that letter, please speak to them in and we'll get the officials to ask. Members, as Clause 16 of the Administrative and Financial Provisions Bill is specific to this committee, we have been requested to undertake scrutiny and report our findings back to the Finance Committee by the 30th of October, which is only less than 3 weeks away, I suppose, is it? Yeah, 3 weeks away. The clause will provide the Department with an enabling power to amend aspects of the Marine and Coastal Access Act 2009, provide DAERA with greater powers to charge fees for marine licensing activities and services it currently provides without a fee. So I'm now going to welcome the following officials from the Marine and Fisheries Division to the meeting and invite them to brief the committee. Colin Armstrong, the Deputy Director of Marine and Fisheries Policy and Legislation, Kelly Mills, the Deputy Director of Marine and Fisheries Operations, and Stephanie Bennett, Principal Scientific Officer, Head of Marine Licensing Branch. Thank you. Feel free to brief the committee. Thank you.
Thank you very much. Thank you, and thank you for the opportunity of coming to provide you with some briefing on the marine licensing clause that is in the bill. So, as I said, I'm joined by Kelly and by Stephanie, and when we get to questions, both they will be able to provide some of the answers on the more operational matters around how the marine licensing system works. So just to build on your background there, we previously provided you with some briefing around the policy proposals for this back in November 2024, and again provided you with a written briefing in March earlier this year. So to recap on some of the context for that and the marine licensing system and the purpose of the marine licensing system is provided for by Part 4 of the Marine and Coastal Access Act, and performs a very important role in terms of how we regulate activities in the marine environment, and in supporting therefore sustainable development within the Northern Ireland inshore region. Examples of the types of activities that we regulate and need a marine licence is things such as the construction of jetties, extensions to marinas, dredging, and the installation of coastal infrastructure. Other activities associated with the sea, such as fishing, they don't require a marine licence because they are regulated through other means, and there's other equivalent authorisation systems were in place and therefore don't need to fall under the marine licensing system. So as well, some of the context for this and the reason why we started looking at these policy proposals is the increasing interest in the marine area and what it's used for, particularly its use for renewable energy. And as we look forward to the future and the types of marine activities and the nature and the scale of those activities that will be needed to sort of meet our climate change objectives and to reduce greenhouse gas emissions. DAERA in the marine licensing system, it'll be important to have an effective and properly resourced marine licensing team in order that we support achievement of the executive's target of 1 gigawatt of offshore wind from 2030. So these significant infrastructure projects, like an offshore wind project, they will require a much greater staff resource. And our department's engagement with those projects and the various developers that will be involved there, that commences very much at a pre-application stage. So there is significant work involved before we ever get to the point of an application being made for a marine licence. As highlighted back in 2024 when we undertook the review of the marine licensing fees and first looked at the powers that we had, what we identified at that stage was that the fee parting charges did not reflect the full scale of all of the services that we provide. So things like pre-application advice, environmental impact assessment, screening and scoping, and then when you get into the post-consent stage, the monitoring compliance of conditions and any scientific monitoring as a result post-consent to ensure that conditions are being complied with. And then also any applications to vary, suspend, revoke or transfer a licence. We did not have the powers to charge fees for those services, and again that takes up a significant part of the work that the marine licensing teams have to undertake. So turning then to clause 16. So what that is proposing is amendments to the Marine and Coastal Access Act to provide DAERA with these fee charging powers, which have already been provided to the other marine licensing authorities that use the Marine and Coastal Access Act. So those powers therefore are with the Secretary of State for marine licensing in the English waters and in Secretary of State waters, and also to Scottish ministers and to Welsh ministers. The amendments will enable the department to charge a reasonable fee for the services and ensure then that we have a more sustainable and efficient licensing system. And this is very important, as we highlighted in the review of marine licensing fees back in 2024, that we enable us to comply with the principles of managing public money, which says that with some exceptions, fees for services should generally be at cost. So the insertion of section 676B, that will give DAERA the same power as taken by Welsh ministers to enable DAERA as the licensing authority to provide advice or assistance to prospective applicants before they make a formal application, and then also to charge a fee for that. Examples of the types of activities then that are currently provided free of charge is pre-application advice through meetings, travelling to sites, any sort of work associated with site visits and attendance. That is all takes significant amount of time, and with a large significant infrastructure project is very time consuming, and again we can't recover the cost for that. Moving on then to the amendment to section 72A. This gives DAERA the power to charge for monitoring activities authorised by marine licences, assessing and interpreting any of those results, and then for also dealing with any variations, suspensions, revocations or transfers associated with that licences. These are all after a licence has been granted, and hence under our existing legislation we are not able to charge a fee for that. The amendment of section 107A and 107B, that gives DAERA the power then to require an applicant to pay a deposit on an account in respect of fees that are paid, and also gives the department a power to recover any unpaid fees as a civil debt. And this is important as it gives the department an option, and many of these things are just giving the department an option to require an advance payment before any of the marine licensing services are provided. Finally, the amendment to section 108(2)A that requires and provides that very important provision of giving a person a route to appeal of any of the notices that are made against them, and it's important to include those provisions in it. So just in conclusion then, these are important to emphasise, these are enabling powers, and subject to the bill progressing through its stages, what the department will then proceed to do is to undertake a review of our marine licensing fees again, similar to what we did in 2024, to look at the new powers that would then be available to us and to look at what the reasonable fees should be. Those would then follow the normal policy development and regulation making processes, and they'd be subject to stakeholder engagement, and again coming back to the committee at the appropriate stages in the policy development and regulation making processes, and undertaking all of the relevant impact assessments for each of those subsequent secondary regulations that would be made. So that's just a very brief overview of the clause and the aspects of it, and I hope we're able to answer any questions that will help you with your consideration.
Brilliant. Thank you so much, Colin. Thank you. I'm going to sort of abuse my powers, Chair, here. Makes me feel really important. So I'm just going to go slightly off piste, if you don't mind, when I have you in front of me. So I'm going to return to that in a wee second. But we do have a letter in our table papers from a community group in Delegated you might be aware of. Just going to ask for your guidance on this and ask. It's something that I think the committee and some of the members from that area would be interested in, because it is in the space of marine licensing and orders. So the background to it is a group that meet once a year and run horses on the beach with small structures and stuff, and they have had help from the department in terms of filling those out. But they do make what seems to me to be a very reasonable ask of the committee to consider if an amendment to the existing legislation is possible. Where and the detail for us, I'm not going to go into it, and I'll share it with you guys. But so this is a small community group that want to run a once a year event, who have been told that they need to apply for a licence for that event. They've offered up an exemption, perhaps. Has the department considered exemptions for these in the past? I know the legislation is from 2011. Has it been something that has been screened out previously, or is it something that the department may be open to?
Yeah, so I'm aware of that letter. We received correspondence from you, and we will prepare a response to you for that. I could see exactly what they were setting out, and that really demonstrates the very sort of approach that's provided in the Marine and Coastal Access Act is that it provides for a licence, or in some cases you can make exemptions. We did do a review of the exempted activities order. Might have been, was it about 2022 we last reviewed that exempted activities order, and before we could do something like that, there would need to be another further review of that. It's about finding that balance of at what point and what is the threshold and the criteria at which an activity should be regulated, and it's important just to have those safeguards in. So we'll come back to you with just some lines in correspondence to sort of set that out, but I think that's very much sets out the nature of the marine licensing system, both in terms of setting fees and setting exemptions. There's opportunities in regulations to decide where the reasonable place for regulation or reasonable fee should be.
I totally get that. It's finding the balance between that community good, not trying to stifle stuff that are bringing measurable benefits too, but also that oversight in terms of. So happy to return to that if that's okay, and we'll communicate with you. So I'm glad that you actually have that and you're aware of it. No, appreciate that. Okay. In regard to then the presentation, DAERA established at this stage whether if the Clause 16 was enacted, is there any new resource required for DAERA, or does the provision exist within DAERA then to manage that?
This wouldn't require any additional resource once that new power that's proposed, which is just enabling power for fees, DAERA would not need any additional resource to use those powers. What they're doing is providing us then scope for things like significant infrastructure projects and for projects that require significant pre-application advice that we can then start just to get improve the revenue that comes back in and use that then to have possibly more people working in a marine licensing team because we're able to recover the costs. So in terms of balancing the budgets, it allows that to happen. But to use these powers, no additional staff is needed.
Okay, and then on the same vein, then the department states its aim is to deliver a more effective marine licensing service by increasing its cost recovery rate, which absolutely makes sense. Is it the aim then to see a measurable improvement in the services provided, or is it simply to balance the books in that regard?
Potentially both,
Okay.
in that we would like to be assured that we have officers available to provide the service. And at the minute we provide it, but we provide a significant pre-application service, for example, but we don't recover any cost.
Okay.
And even variations can take a great deal of resource. It's that prioritisation of the resource. And so potentially that would give us a revenue stream to allow us to be able to always provide that effective and efficient resource and to be available. Where at the minute, because we don't get a revenue stream from that and we charge for marine licences are the priority, whereas we get a lot of benefit from pad advice, for example. So it is about going forward. We don't anticipate that we'll need too many more staff in terms of this. This is about some cost recovery to a significant extent, but that would assure us that we would be able to provide that resource.
Is there any quantification of applications for marine licences or the anticipated application? I imagine in terms of the green energy division, perhaps, wind energy or sea energy, whatever. Is there an anticipation there's going to be an increase in applications and therefore the resource would be even more important to back up?
Yeah, we're certainly expecting to achieve the 1 gigawatt of offshore wind target. So currently there is a number of companies who are engaging in pre-application, but there is actually no licence yet for anything, and will not be just even for in the immediate future, but the work in preparing for that has commenced. So as those progress through the preparation stage into the license stage and then into the consenting stage, there absolutely will be new work, and that's what we can see coming ahead that we need to do this preparatory work for, so that once the applications are there, we're actually ready to take them and deal with them and move them through to the full part of the consenting process. Okay,
I've got one wee final one, and it's slightly off pace to Ian, but it's to do with there's something rattling about my head about we just had a dilapidation building meeting. So I've just this running concern that a company comes in, makes the application, starts their works, starts driving big piles into the sea, and then all of a sudden doesn't deliver on the future of the project, as in leave something standing. It might be outside of your areas and your remit. What does, have you any idea what the department does in that space? Is this like where a bond is paid, the license fee is recoverable, and that type of stuff? Is there anything in there in terms of the length of the project? So it's okay getting the license to enable the works. But what happens if the thing collapses halfway through? The project. Is there any space in that? Is there any powers in the license then to? It's an obscure question, I get that, but it's like leaving derelict infrastructure in the sea.
There is a duty, and there will be a duty to decommission and to remove and to leave the sea as it was. There is work being taken forward on that. at some stage with our colleagues in the Department for Economy.
Okay.
And the Department for Economy will have some responsibilities with that, so we just need to fully tease out the decommissioning process. Is there anything in marine licensing at the moment generally about that?
You have to consider it, but there's no fees yet linked to the decommission.
I'm just thinking of the example we have for road bonds and things like that. If someone wants to break a curb, to cross a pavement, to do whatever, there's a bond to tell till it's been reinstated. And I think if it's used well, it's a system that we should be doing. In turn, it could be picked up in the licensing, and that would because we've got lots of investors who make a really good case for what they'll do and what they'll do for all of us. But inevitably, if sometimes we're left holding the baby, sometimes so I think licensing is the place to do it. So if it's something perhaps you could even investigate, might be economy, might be on it, but if you could.
There's work I don't have,
Okay.
just my lines exactly with it. There's work that we have been discussing with Department for Economy around the decommissioning and a decommissioner of last resort.
Yeah.
And we can come back to you with a wee bit of clarity around that if that would be helpful for you.
Really appreciate that. Thank you so much. Declan?
I'll ask my question and follow-up question in one. In your presentation, Colin, you mentioned about the reasonable fees to ensure an effective licensing system. How are those reasonable fees determined? And I suppose a follow-up would be, is there a possibility that those fees could deter people from applying for the necessary licences?
Really, the approach that we took in the previous review of marine licensing fees and to set was to do some benchmarking around that. So we first of all looked at exactly what it was costing and the staff resource cost of the marine licensing team, and then compared that to the equivalent fees that were applied by the other marine licensing authorities and what was paid for the equivalent consenting regime within Ireland. So we did do that benchmarking as well, and that was the approach we took, and that would be the exact same approach we would take to setting a reasonable fee if these new powers are provided to us.
So that's okay, that's fine.
Thank you. Members, are there any other questions? Sorry, Anya, yes?
A quick one from myself, Chair, just in relation to the new powers. I note in the presentation, if you just get it up here, there's comparison made to GB and the Republic, particularly in the south. The Maritime Area Regulatory Authority is the body responsible. How's the new powers that DAERA are proposing, how do they compare to the existing powers in the Maritime Plan Act in the Republic?
I hadn't done a complete analysis of the contrast to that as to where we sit in terms of the level of fee. It's broadly similar approach, but just the nature of the way their system has been set up more recently compared to the Marine Coastal Access Act, there will be some differences in it. I'd need to go into a bit more detail around just exactly what the level of fees they put on it in doing that, but that's the sort of stuff we would do in the review of the regulations and the fees when we get to that stage.
No, that's okay. I think anything that you could maybe even come back to us, whether it's written, it'd be great to have that information. Thank you. Thank you.
Sonia. Any other questions, members? Okay. Thank you very much, and thank you for taking the curveball questions from me. It's actually turned out to be a good question, I think, actually. If I do say so myself, because nobody else is going to give me praise, So thank you very much for your time, members. Thank you. Do you want to offer me praise there, Michelle? No? No? Give me any praise there? No? That's my great question. Okay, members. We're now on agenda item 10, and thank you. We have managed to make up a little bit of time. And that we're going to take a briefing from the Marine Taskforce Marine Licence on that, Clause 16 in the Administrative Financial Provisions Bill. There is no briefing paper for this item. I'm going to welcome the following representatives from the Marine Taskforce to the meeting and invite them to brief the committee. We will have Robert Walsh, Northern Ireland Marine Taskforce, Jade Berman, the Coastal Advisor for National Trust, and Matthew Lundy, the Head of Marine Recovery at Ulster Wildlife Trust. heat comes from the work of the members, just so you know. We're very industrious in this committee. Okay, I've already introduced you guys, okay?
Oh, fantastic.
You're guys and gals. So when you're ready and comfortable, if you just want to brief the committee then and take a few questions, that would be great. Thank you.
Yeah, no problem. Thank you guys, thank you Chair and Committee for the opportunity to present our insights. I'll briefly explain who we are, just for those who are unfamiliar, outline the state of nature and the overview of policy developments which require marine licences, which my colleagues will then go on to explain in further detail. So the Northern Ireland Marine Taskforce, we're a coalition of 12 environmental NGOs working to develop marine environmental policies across Northern Ireland. Established in 2007, we ensure through our marine vision healthy, productive and resilient seas for Northern Ireland. Our remit covers from Lough Foyle round to Carlingford Lough, and we represent Northern Ireland within the Environment Links UK at the UK level through the Northern Ireland Environment Link. The most relevant themes of our marine vision with regards to marine licensing are the sustainable development at sea and the recovering biodiversity. Before we assess the impacts from marine licensing on the marine environment, it's important to understand the current state of nature in Northern Ireland and its relation to the rest of the UK. We are the 12th worst out of 240 regions for biodiversity loss in the world, as of a report in 2021, whilst the 2023 State of Nature report highlights that 12% of species were assessed with the threat of extinction across both terrestrial and marine. The report highlighted that the birds of conservation concern in Ireland's red list has tripled from 18 to 54 species since 1999, and at the UK level, a recent review of the UK Marine Strategy shows that we've increased the number of indicators that are failing to achieve good environmental status from 11 to 13 out of 15 indicators, showing the poor elements of ocean health. According to the Office for Environmental Protection's review of drivers and pressures affecting the UK marine environment, declines in nature have been attributed to poor governance, missed timelines, climate change, unsustainable activities, and other associated cumulative pressures, such as water pollution, and these must be addressed. With the return of the executive, we've seen marine conservation policies progressing, such as the Marine Protected Area Strategy Review, the Lasmar Conservation Strategy, and the Seabird Conservation Strategy and Action Plan. There are also additional industry-related developments such as the Offshore Renewable Energy Action Plan through the Offshore Renewable Energy Forum and fisheries management plans through established working groups and the offshore MPA management through COFISH. The developing policy areas are flagship initiatives for our region, but the processes underpinning delivery need to be agreed and understood. You'll be aware that there are nature restoration targets and ambitions through the Environmental Improvement Plan of last year and core targets through the Programme for Government, which relies on the delivery of aforementioned marine conservation policies, such as the newly finalised Blue Carbon Action Plan, which was co-designed with the MPA strategy still in development. The Blue Carbon Action Plan outlines areas which delivery partners are capable of progressing policy objectives through their projects, but as my colleagues Dr. Matthew Lundy of Ulster Wildlife and Dr. Jade Berman of National Trust will go on to explain, there are both opportunities and challenges with marine licensing to both active marine conservation and challenges of coastal management, respectively.
As Robert, who's the Taskforce officer, has outlined, we're in a very busy policy space recently with a lot of emerging strategies coming out of DAERA and other departments. Marine nature recovery is a public good. Restoring salt marsh, seagrass, meadows and native oyster reefs is essential for reversing decades of habitat loss in UK waters. These habitats deliver critical ecosystem services, carbon sequestration, water quality improvement, biodiversity support, and directly support DAERA policy objectives and wider environmental targets. We have seen significant salt marsh loss. Around 85% of salt marshes have been lost since the last century. Seagrass meadows, more than 90% have been lost since the 1930s, and native oyster reefs around 90% decline. Native oyster and it effectively extinct in the UK. With this new policy landscape, we will now require on-the-ground delivery. We are entering a policy landscape shaped by emerging and established strategies. Delivering these strategies will require physical habitat restoration and cross-cutting actions. That demands engagement across departments and will require, for those works, marine licensing. Restoration must be delivered at pace and at scale to successfully implement those existing and strategies where so much work has gone into in the last number of years to deliver. These restoration projects are pioneering. They're uncharted, they're novel. We don't know the process by which to get them on the ground. They're first of their kind. We don't have an established blueprint. The regulatory pathway is often unclear, particularly whether marine licensing is required, exempt, or subject to additional permissions. This demands iterative cross-sector collaboration. We have experienced constructive engagement and support from DAERA and are committed to enabling and delivery despite this complexity. However, the approval phase remains resource intensive and the processes can be lengthy and unpredictable. Introducing additional complexity or indeed additional resource requirements at the approval stage risks delaying or preventing restoration due to capacity constraints. Conservation organisations are working for not for profit but for public benefit, delivering those ecosystem services such as water quality and nutrient management. Yet we face the same regulatory processes as commercial sectors. Most of our work is funded through short-term grants, fixed annual budgets, and the consenting and approval costs and timescales are unpredictable. Deviations from funding applications may make those ineligible and come at the cost of our own organisations, creating planning and delivery risks for time-sensitive restoration and projects. Marine recovery is embedded within current DAERA policy. Strategies are in place and now we're in the delivery phase. These are often led by third-party organisations such as the members of Northern Ireland Marine Taskforce, where the actions requiring marine licensing are part of a wider strategic delivery. The consenting framework should be considered strategically to ensuring effective implementation. We would like the Department to co-design a dedicated streamlined pathway for recovery and natural restoration, ensuring these pioneering projects are delivered at scale, pace and for public benefit.
So I'm going to give a few examples of work from National Trust. So just to provide the context here, National Trust manages 22% of the coast here and a third of Strangford Lough. We carried out the first managed coastal realignment work in Northern Ireland back in 2009 at Anns Point on Strangford Lough in partnership with the Rivers Agency and NIEA. And we recently aligned the site again with support from the Marine and Fisheries Fund Blue Carbon Strand. We have commissioned, thanks to the DAERA Environment Fund, further work mapping salt marsh and other blue carbon habitat around Northern Ireland, identifying potential areas for restoration and blue carbon capture, which aligns with the goals of the recent Blue Carbon Action Plan produced by DAERA through the co-development process, working with ourselves and other stakeholders. The Coastal Forum also brings together the ministers for DAERA and DFI and the chief execs of the coastal councils and the director of National Trust, and the development of the Coastal Observatory has supported the first baseline survey of the whole coast of Northern Ireland. However, we are still behind the rest of the UK in developing shoreline management plans or an equivalent process. Despite the warnings of enhanced future coastal erosion rates and sea level rise and recent severe erosion impact events, which impact not just on nature but also infrastructure, economic and other assets too. The Coastal Monitoring and Adaptation Planning Project, CMAP, which is led by Ulster University and has 19 partners, including the associate partners, is funded by Peace Plus, will increase this evidence base and also pilot coastal adaptation plans and toolkits co-developed with local communities and decision makers, which will support future decision making around our coast for people and nature. But in order to take the right action, we need the support from marine licensing to ensure the right activities happen in the right place. And there is a need for the department to be able to recoup the cost of service delivery under its responsibilities for managing public money. However, we also recognise that marine restoration projects are often trying new methodology, and the expense, if the government is to charge by the hour, can be significant. Currently, the flat fees are set in relation to the cost of carrying out the works. There is a risk that including nature-based solutions in the works will be dropped off from other developments as they increase the costs. So I have an example here from England, from National Trust, where the MMO, so the Marine Management Organisation across the water there, has had a consultation proposing their fees go up from £122 per hour to £155 an hour for marine licensing. We have a salt marsh restoration project over there on Northern Island in Essex, and currently with those sort of per hour fees, we've spent over £55,000 just on marine licensing fees to carry out a restoration project. And so that's a significant proportion of that project cost, which means you can do less. So we do recognise that marine licensing fees are necessary, but they should be reduced where there's positive environmental impact. And there is a need for blue carbon and other nature-based solutions for future marine and coastal management. It is vital that the financial cost of carrying out public good above the statutory minimum is not penalised by costing more in terms of licence fees. And there are exemptions in the south here under the Island SI number 402/2023 Maritime Area Usage Regulations. And there is also discussion in Scotland about exemption for restoration, and there's been discussion through English Natural Heritage too. So, you know, this is moving in that direction. So just to sort of summarise that, licensing for marine natural recovery and restoration must be reformed and tailored specifically to marine nature recovery and be better aligned with the funding process. For example, the time taken to marine licence and to process those should not prohibit participation in short-term funding cycles. Marine nature recovery and restoration should be recognised within the licensing system by developing a separate class of licences for marine recovery and restoration projects, which includes a dedicated outward-facing administrative team. And increasing that regulatory flexibility would also enable conservation projects to trial approaches and monitor impacts and interactions with other species and habitats, enabling a greater number of candidate sites available, particularly for active restoration activities.
Thank you very much.
No worries.
Really do appreciate that. I find your work absolutely fascinating, as you know, and thanks for your hospitality a number of months ago on my birthday, if I remember. There was no cake there. You just missed a beat there. So thank you so much. If you don't mind, the questions today will be very focused in and around Clause 16. That's the bit that we have been tasked out of the Financial Provisions Bill to bring some clarity to. So if members would also try and keep their questions in that space. And I'm sure, hopefully it doesn't stray too far, but there is a lot in what you've said of huge value. Genuinely do believe so. In regards to the opportunities that you've highlighted, and possibly speaking maybe in and around the exemptions for restoration and things like that, did you engage as a collective with the department in this, and did you do anything in and around the consultation that might be useful for us to try and tease out and assist us as we...
Yeah, so we've submitted a response to the marine licensing consultation prior and attended some of the consultation workshops that they had in relation to the marine licensing process and sort of...
Specifically in regard to Clause 16 and the piece that we're doing in around the fees and levy of fees and stuff, yeah?
So to be more specific,
yep.
there is a response to that we sort of submitted to DAERA there when they had the consultation back in.
Would you like to then, you can share off the back, you can, if you...
Yeah, I can share that with you.
Could you share with the committee?
Yeah, no problem.
Thank you very much. That would be really useful. Thank you very much. Declan?
Yeah, thank you. In your presentation, you made references to the habitat loss and water quality and the seagrass meadows disappearing. How do you specifically, or do you believe that the Clause 16 provision will help reverse that and help you do the work that you do?
It's within the potential for the flexibility for allowing more streamlined licensing allow those projects to happen in a timely manner. We work often on short-term funding, annual basis. If there is agreed frameworks and known strategies and pre-approvals effectively when they're coming supporting DAERA policy, if those flexibilities and categories of licensing are there, we can plan much more effectively the restoration work that we do. We do restoration. We're doing work on the ground or on the seabed to deliver work that will require marine licensing, and it's making sure that can happen in the urgency and in a timely fashion to allow.
So, Chair, just rather than being funded year on year, if you had like a multi-annual approach, that would let you plan ahead and do adopt a more longer term strategy.
Be somewhat specific. Say, for example, for the Blue Carbon Fund at the moment, we've not been able to apply for that because of the short term nature. It would not have the time to get through the licence in time to be able to carry out the work in the time of the funding schedule, and that would go for Ulster Wildlife and ourselves. So therefore we can't spend the money to do good, and that becomes a hindering point in relation to that sort of support for that.
And a lot of these restoration projects are more than just on an annual basis, as I'm sure you understand.
Thanks, Declan.
Thank you.
No, thank you. Good question. John?
Yeah, thank you, Chair, and thanks to all of you for your ongoing work, first of all, and for your presentation today. The Chair has covered some of this around the implications of the Clause 16 and the powers and proposals that might flow from that, pardon the pun. I'm keen to know, maybe just for our benefit, could you give any examples of frameworks in which you're already involved with the department? And I know there are some, we've heard of them already. And then secondly, have you already tried to use those frameworks to overcome this funding problem? And if not, if there hasn't been an opportunity to do that, might there be opportunities in the near future to try to use those frameworks to get to that?
Just probably a very effective framework which is in place in the department at the moment is the pre-application discussion, where you have a process by understanding the scope of work, and if that is exempt or requires marine licensing, you get therefore quite an expedited response to that, and knowing then how you proceed. So we have been through a number of those pre-application discussions to see the scale of work that would be exempt or would be required to go ahead, and that allows you then to make a concrete plan.
So there might still be opportunity to make progress on the exemptions required in the interests of protection and restoration.
I would think so, yes, because at the moment, if you sort of give the specific answer, it goes through as a commercial licence. So therefore, it has to go through all those processes as a commercial licence rather than, for example, as a different type of project. And so the commercial, for example, for dredging, it's up to 10,000 tonnes is the minimum level there. And so if you're doing a small community project, such as we've done in Cushendun, removing some of the sand, which was 2,000 tonnes from the boat ramp for the community, then that comes in as a larger project. So that at the moment, with the new fees that just came in, without the additional fees for Section 16 on top, would be like about £9,000 that you'd have to put aside for that community benefit before you've even considered the additional costs on top of the sort of speaking to people and the hourly costs. So I have the examples there from the MMO about their costs. And so, I don't know what costs are being discussed, because at the moment it's just the ability to have costs. However, that is causing issues, and it may also cause issues of developments going ahead without going for licensing because of that sort of shift. So you may end up with more issues around enforcement.
I think the Chair, secured an agreement there that we would see some of the responses you had put forward, and I think that could be helpful to keep us briefed on how to. That community-related project you mentioned there in Cushendun, these would be crucial, not only for the use of facilities and access to areas and nature, for that matter, for local communities, but also for the protection of nature, and that's fine. Yeah.
Just interestingly, you wouldn't have been in the meeting before, but we had the department and we were talking about the 2011 Act rather than Clause 16, and it was about the potential for exemptions for not specifically this, which is restoration and nature-based, but was community activity. So it was in and around Doherty and horses on the beach and that type of stuff. So and there's a lot of stuff that can be good. So I think we do need to keep our eyes open in regard to this one and ensure we're not stopping good practice or inhibiting it. And so we should be encouraged. In many ways, we should be encouraging it and not making it so. £9,500 of unrecoverables just to do some good doesn't make a whole lot of sense. Okay, thank you very much. Any other questions, members? Are we good? How's about that? Well done. They must like you a lot. They must like you. Thank you so much for your time.
Thank you guys so much. Thank you. Thank you, committee.
Maybe get out to look at these oysters next time. It was a bit choppy that day, wasn't it?
A little bit choppy. Yes.
Thanks. Okay, members. We're not going to take a bit. We're just going to pile through quite a bit still to get through. So agenda item 11 is the departmental oral evidence session, the SL1, the farm sustainability payment schemes, eligibility, etc., regulations, Northern Ireland 2025. Refer you to the SL1, the draft SR and the explanatory memorandum, starting at page 2. The department intends to make the SR under the draft affirmative procedure to provide it with the legal powers to implement the farm sustainability payment. As you will recall, on the 26th of June, we were briefed on the FSP, which forms part of the Sustainable Agriculture Programme and will replace the current Farm Sustainability Transitional Payments with effect on the 1st of January 2026. Members, now I'm going to welcome the following DAERA officials to the meeting and invite them to brief the committee: George Moffat, the Acting Director of Agriculture Policy Division; Lorna Christie, Head of the Farm Sustainability Development Policy Branch; Aidan McAvoy, Head of Controls and Assurance Development Branch; and Gregor Kerr, the Programme Director, Future Implementation Unit. Thank you. You're no strangers now. Okay. Once you're settled, if you want to brief the committee, that would be really useful. Thank you.
That's great, and thank you, Chairman, for your introduction and for the opportunity to come to committee today and present on the draft Farm Sustainability Payment Scheme Eligibility, etc. Regulations Northern Ireland 25. And you've already mentioned I'm joined by Gregor, Lorna and Aidan. The committee previously received a written and oral briefing on the FSP scheme on the 26th of June and at the party political spokespersons event in Loughry on the 5th of September. And the SL1 you've received for today's discussion reflects those discussions at those meetings and also introduced a number of technical changes. As the committee is aware from previous briefings, a public consultation on the proposals that now make up the Sustainable Agriculture Programme was undertaken in late 2021, and the responses informed 54 policy decisions that were announced in March 22. A number of these decisions related to the establishment of a resilience payment, subsequently renamed as the Farm Sustainability Payment. And as we've taken forward the development of this payment and of this new scheme, the Ag Policy Stakeholder Group has been instrumental to its development. FSP will replace the Farm Sustainability Transition Payment and will act as a balance between providing a safety net which will help a farm business withstand shocks that are beyond its ability to manage effectively and encouraging farm businesses to become more environmentally sustainable, efficient and resilient. The introduction of FSP will see the rollout of the following key policy changes: implementation of the historic years exercise, progressive capping, new land eligibility rules, new farm sustainability standards to replace cross-compliance, and the introduction of conditionalities. The Farm Sustainability Payment Scheme Eligibility, etc. regulations will give DAERA the legal power to introduce the payment and the various elements outlined with effect from 1st of January 2026. The minimum claim size for FSP is retained at 3 hectares, and applicants for the scheme in 26 will need to activate 3 entitlements on 3 hectares of eligible land to meet the requirements of the scheme. The historic years requirement was included in the Farm Sustainability Transitional Provision regulations made earlier this year. The regulations we are discussing today amend the transitional regulations and clarify that businesses not meeting the historic years requirements will not be eligible for the FSP scheme in 2026 only, and that their entitlements may only be transferred to an existing eligible farm business. The regulations introduce progressive capping of FSP payments phased in over a 2-year period for payments above 60,000, with capping levels increasing in stages based on the size of payments. They also introduce simplified land eligibility rules for the FSP scheme compared to the land eligibility rules in place previously. The objective of these revised rules is to establish practical land eligibility rules that complement the FSP scheme's objectives, can be easily understood and be efficiently and effectively controlled. The regulation includes a list of features and land use types that will be ineligible for the FSP scheme. For example, building sites, public and private gardens, public parks, golf courses. To support the simplified land eligibility rules and mitigate against any unintended consequences, the regulations amend the eligibility requirements for the FSP scheme to state that only active farmers undertaking agricultural activity are eligible to apply. They must also have management control of the land used to activate entitlements. Consequently, the regulations require applicants for the scheme to carry out agricultural activity on at least 3 hectares of land used to activate entitlements. However, where an applicant submits a claim of less than 5 hectares, they must carry out agricultural activity on at least 2 hectares of land. To ensure equality across schemes, the land eligibility rules introduced by these regulations will also apply to EFS hire agreements which were made by the Department before the date on which these regulations will come into operation. The regulations legislate that applicants for the FSP scheme will be required to meet the following conditionalities in order to receive their full payment, and these conditionalities will be phased in. Firstly, participation in the Soil Nutrient Health Scheme. Farm businesses must have registered for the soil scheme and completed training offered to it by the closing date of the single application form window of the 15th of May 27 to be compliant. For those farm businesses that are not compliant at this stage, the regulations legislate that a 10% reduction will be applied to their farm sustainability payment in 27. This reduction will be increased to 15% for continued non-compliance in 28 and will continue to be applied at 15% until the conditionality has been met. Secondly, participation in the bovine genetics project. In this case, farm businesses must have registered for the project and completed training offered to it by the closing of the single application form window of 15th of May 28 to be compliant. As with the SNHS conditionality, for those farm businesses that are not compliant at this stage, the regulations legislate that a 10% reduction will be applied to their farm sustainability payment in 2028. And this reduction will be increased to 15% for continued non-compliance in 2029 and will continue to be applied at 15% until the conditionality has been met. The regulations also legislate that penalties for failure to meet these FSP scheme conditionalities should be applied concurrently. A third conditionality of participation in the carbon footprinting project is also planned, but this conditionality is not included in these regulations as the timeline for the rollout of this project has still to be set. The regulations reset the 2-year entitlement confiscation rule from the commencement of the scheme, meaning that no entitlements will be confiscated for non-activation in 2026. This is because the FSTP and the FSP schemes are being treated as two separate schemes. In relation to technical changes included in the regulations, they define the order in which DAERA will apply scheme penalties, and these are as follows. Firstly, the over-declaration penalty, which includes duplicate fields. Next, the late claim penalty, followed by conditionality reductions, and finally FSS penalties. Under-declaration and late field penalties have been removed, and the penalty for over-declaration of land has been increased from 1.5 the difference found to twice the difference found. Preliminary checks will no longer be mandatory, and the Department retains the authority to implement other checks as required. The mandatory on-the-spot checks inspection rate has been removed and replaced with the requirement for DAERA to define the rate, as land eligibility controls will be carried out using remote sensing techniques, thereby removing this requirement. The regulations remove penalties which exceed 100% of the payment due in respect of what were previously area-based payments under Pillar 2 of the Common Agricultural Policy, chiefly agri-environment and forestry payments. These penalties apply to a very small number of businesses and are complicated to administer as they involve a deduction to payments in following years. And finally, the regulations simplify the requirements regarding control reports for farm sustainability standard checks. Chairman, that brings me to the end of my presentation. I hope you found it helpful, and we're happy now to take any questions. Thank you.
Brilliant. Thank you very much. I appreciate that. And there's going to be quite a few questions. First one that I'm going to ask is in regard, it's in regard to the requirements and the conditionalities to receive, and it says here they're full FSP. And this is one we sort of beat around with the bovine genetics team last week. So they were pains to point out that there would be no, for someone who didn't enter that scheme, there would be no loss. But in this paragraph here that I'm looking at, says that a participation in the bovine genetics project is essential to receive the full FSP. Could you be very clear as to what element of the FSP they would be ineligible for, or what that is quantified, how that's quantified?
They're eligible for the full FSP payment if they haven't participated in the scheme by the date set. They'll lose a 10%.
But if they haven't not participated, if they haven't applied for the scheme?
If they haven't applied and it's been offered to them, they'll lose that reduction will be applied until they rectify that.
So I'm going to be honest, that's not in any way what I took from the presentation last week from the DAERA officials. And this is going to probably be where we'll push this about. It's up to members where to go with this. What way it was presented to us last week, it wasn't a mandatory scheme at this stage for FSP, that it was mandatory and it would be cost recovery and being worked out at £13 per head because that was the cost that had been required. This moves it into a very, very different phase, I have to say, from the presentation we got last week, guys. Yeah. I need to nail this down once and for all, because what I don't want is to spend the next 20 minutes trying to tease out the absolute. So that genuinely, that is totally different from what we were told last week.
For bovine genetics, there's two elements.
Yeah.
So there's the registration and training part, which all farm businesses will be required to do, and that's where this conditionality comes in. The point you're raising there, Robbie, around the £13, that's for genotyping. So that's a requirement of bovine genetics. The department is funding that in the first year, but are currently looking at options for how it would be delivered from there on in. So at this point in time, there's no plan to include that as a conditionality, but the conditionality purely relates to farm businesses initially registering for the scheme and doing the training. The genotyping is separate.
Okay, and that is, how much of that's already picked up? How much of that's already happening?
In genotyping?
Yeah.
There are some farm businesses who genotype at the minute, not a big number, and I suppose the purpose of the whole bovine genetics project is to improve the genetic pool of bovine cattle right across the industry.
In terms of the wider genetics project, then, how much of that's happening at the moment?
At the minute, the supplier has been appointed to build a database to hold the genetic information that will come forward. The plan is that farmers will start to provide data for that, and that the training then will start and the registration will open from September next year.
Okay, that clears a little bit of it for me. And again, it's that push and pull. Okay. Do you think that farmers may be put off making an application due to the conditionalities imposed in addition to the current farming pressures they're experiencing? And what I'm trying to pull apart here, and this is slightly unfair to ask you, but everything seems to be linked, even if we're told it's not linked. Like cross-compliance is kind of moving, but in terms of non-adherence to one part, that it does kick in another part of the farming schemes and stuff. Has there been enough work done to gain the confidence of farmers? Because, as we've said before, I don't think there's a member in here who doesn't want that to work, that bovine genetics is incredibly valuable. Yeah, it looks like a good idea.
I think if we go back to the rationale for the payment, it is a resilience payment to really help farm businesses withstand shocks, become more environmentally sustainable, and really be there for the future and be productive and profitable. The department and the executive is investing heavily in these data platforms, the bovine genetics, the soil nutrient health scheme, and really the data that these platforms will provide to farm businesses. It's really beneficial data to help them make change within their business to improve that sustainability, to improve that resilience. And really, by applying the conditionalities, we want to ensure that as many farm businesses as possible join those schemes, participate in those schemes, and get the benefits that those data platforms can deliver. But you're right. We've talked to industry about them. Communication and messaging will be extremely important going forward, and we have a detailed comms plan planned around this. Once the legislation is in place and we can take this out.
To be absolutely fair to this, we got a good understanding of the genotyping and what's involved in that. In terms of participation in the bovine genetics project itself, how much work is involved for a farmer to participate in that?
Really, it's registration and doing the training, and that training will be available online that the farmer can do at his or her leisure. But also, it'll be offered face-to-face for those people that maybe aren't as IT literate or just prefer that opportunity to engage in a one-to-one or in a group scenario. So it will be quite easy for farmers to participate. I think the other point to bear in mind is the conditionalities, the two at the minute, are being phased in. So, if the farm business has met the soil conditionality, it comes in first, then bovine genetics. If they meet it, then they'll have no reductions applied at all.
When do you anticipate the bovine genetics project starting? After if the SR is made?
Well, the genotyping, and I know the committee considered the SL1 for it a couple of weeks ago, and it's still to be led yet. The project itself is up and running, and that the supplier to build the database, as I mentioned, has been appointed. Sustainable Rumen Genetics, the industry-led body, is in place and is working with the industry to encourage participation. So over the next number of months, there'll be a lot of work and communication around it to really then have farmers geared up and ready to apply and register from September onwards of next year.
And 15th of May 2028 is the date that's here for... Is that go live or the applications opening?
No. The applications for farmers to register and complete their training will be available from September 26. Okay. Basically, if they haven't registered or completed the training by that date, the closure of the single application period in 2028, 15th of May, those businesses then will get the penalty or the reduction applied to their FSP. But before that, there will be messaging going out and letters going out to remind farm businesses of the need to meet that conditionality.
And the final one for me then is on capping. It's obviously a new way of doing this, I suppose. Is there a risk for those bigger farms where that is the only business that the farmer has? So some farms, obviously, as you know, the other businesses or other occupations is up, but for the bigger ones who rely on their farming, is there a risk that this could be detrimental to them? Do you see? And in terms of working out the scale of the capping, could you just give me a wee bit more around that?
I'll pass to Lauren to pick that up, Robbie, don't mind.
Okay, in terms of the scale of the capping, it is being done and introduced over bands of payment. There are 265 businesses who are going to be impacted by this. And of those, the majority of them are sitting at the lower levels between 60 and 100,000 of a payment for the individual farm businesses. In terms of how that's going to impact the farm business, this was announced 4 years ago, and so farms have been aware that this is going to happen, and so we're bringing it in over a 2-year period. So there will be 50% of the cap introduced in the first year, and then that will go up to the 100% of the rates in the second year.
Is there any figures for, just as a final one for me, and I'm going to invite members in, is there any figures for, so that's you can be 265 larger businesses that are going to be affected. Is there a metric, like is there an average in there where there will be a reduction for any, is there an average reduction or not? Do you understand? No.
There's not, because it's difficult actually to work that one out, but if you think of somebody who has a payment, a farm business that has a payment of £70,000 in the first year, they will only be, repayment will be reduced by 10%, which will be £1,000. Okay. In the second year, it'll be 20%, that will be £2,000. And obviously, if there's somebody who is sitting at the other end who has a farm payment of £180,000, that will be just reduced more.
Yeah. Okay. I think I do remember the table that you did provide, because that was there. Thank you. Okay, Declan.
Yeah, thank you, and thank you very much for the presentation. You see, in relation to the farm business that were effectively knocked out because of the historic years, has the department been engaged closely with those businesses, and have you noticed the pattern where they are making arrangements for transferring their entitlements?
Gregor, do you want to pick that one?
There have been some businesses who have appealed against the decision, if you like, and put in evidence, and that's been considered. And where it's been found that the department's information was incorrect or incomplete, those decisions have been overturned. Businesses brought in, but in terms of what businesses are choosing to do with their entitlements, we wouldn't hold that data at this time. We'll not know that until we get to what's called the trading window next year, which is when they have to notify us of what they've done with their entitlements. So at the moment, we wouldn't hold any of that data.
Thank you. That's it.
Thank you, Declan. Michelle?
Yeah, happy to. Thank you again for your presentation. And obviously, we have we've spoken about this in the past, and I have raised my concerns, particularly in relation to the issue around capping and the rationale that's been placed around that. And I'm not convinced that that high, as you say, high support payments encourage unwarranted risk taking. I do think that I'm not sure that you're actually doing a business a favour by reducing the support that they give. In many respects, I think that you need to incentivise entrepreneurism and obviously progress within the industry, as opposed to in some ways maybe disincentivising progress. I am further concerned about sort of carrot and stick approach, particularly around the bovine genetics programme. I'm on record as saying I think it's a superb programme, and I do think people should be encouraged to do that. But I am really concerned about the manner in which the department is going about this, particularly around placing conditionality on payments, and I don't think that was ever to be the intention of the scheme, and that worries me that essentially what you're saying is that while you're signing up and getting trained for the project, the next step isn't penalised. But I think it's nearly as if that will be your intention to do that. So I suppose we're moving towards that. Added to the conversations that we had last week around penalties as well, which is all part of the same process. I do struggle with how this has been presented, and that's being honest with you. I do think, set in the context of where farming families currently are, that they will see this as a further choke and a noose around their neck. If you're looking at capping, penalties and conditionalities, I don't see really where the incentives are. That's more of a comment than it is actually asking for a response, because I know that we've had these conversations before.
Yeah. I think, I know we've discussed before, we did consult in year 21 on proposals around applying conditionalities, and the response at that time supported those. And I suppose the key message to leave today is that we don't want farm businesses to be receiving penalties for non-participation. We want farm businesses to participate and get the benefit that these platforms will deliver. And really, we do plan comms and marketing and promotion around both of the conditionalities, really to ensure that farmers aren't in a position that a penalty will be applied. There is work to be done, and we realise that, but we do plan to get out there and get that message out.
Not really.
Okay. Any questions? William, yes?
Thank you, Mr. Chairman. Thank you for your presentation. I had some concerns. You do say on the bovine genetics scheme, you have from September 26th till May 28th to apply. Is that?
To register and complete the training, yes.
So yeah, 18 months roughly.
Yeah.
I just have concerns that the message needs to be very clear, because you could have had a small suckler farmers that don't fully understand and don't register and end up being penalised through no fault of their own. In the past, it wasn't made many penalties, metrics weren't made clear to farmers.
Yeah, and I appreciate that, William. And as I said to Michelle, we know there's a job of work to be done around the whole comms and promotion of the schemes, the data platforms, and the conditionalities. I know CAFRI are planning training events and awareness events, both for farmers but also for agents and for other agri-professionals that will be engaging with farmers. And really through that, it's trying to get the information out to farmers that they know exactly what they need to do.
See, there's going to be a penalty for over-declaration. It was previously a penalty for under-declaration, so you're jumping from one end of the stream to the other.
Yeah. There previously was a penalty for over-declaration, so we're maintaining it, but removing the other one. So in some ways we're simplifying the penalties around that. Ian, I don't know if you want to pick anything up there. McGregor?
I was going to say, it would be quite difficult for an over-declaration, given that you need entitlements to claim anyway.
with the over-declaration penalty is where you declare more land than is actually eligible, or more land that you hold. So because of the changes in land eligibility which have come in, it means that the soft features are no longer ineligible. So what might have happened previously is a farm business might have declared an area in a field, and then when that field was inspected, we found there was rush in the field, and so that area is ineligible. So there was an over-declaration penalty applied because if rush was ineligible, but that's been removed now. That soft feature is now eligible. So for the majority of farmers, the only time that you'll have an over-declaration is if you have a hard feature that you don't tell us about, because we know where the hard features already are. So if there's a small
buildings,
if they built a new building and didn't tell us that there was a new building but tried to claim that, and that's when there would be an over-declaration penalty. But
a building would be taking up a very small portion, like
exactly.
It wouldn't be wise for a farmer to declare it intentionally.
We wouldn't expect that, and because they have more eligible land now, with the soft features now being eligible, most farmers, shouldn't be in a position where they need to claim anything other than what they have. And as a point you mentioned previously, Mr. Berman, is that we will pre-populate their claim with the areas of all the fields that they can claim. So it will actually all be in there for them. So it's only if they've done something, they've put in a hard feature, then haven't told us, that's the only time that would arise now.
There was a situation in bygone days where duplicate fields, many farmers were fined heavily for duplicate fields, and much of it was a mistake. But given that on the computer, nobody could claim for 2 fields because it would kick it out anyway. But a lot of people are fined very heavily in the first instance back a number of years ago.
Duplicate fields would remain a case where, however, what would happen is that when the applications are made, if we find a duplicate field, we will write and contact both of the farmers involved and tell them this field is being claimed by someone else, and then that allows the farmer who has mistakenly claimed it because they were farming it last year and not farming it this year to remove that from their claim with no penalty.
That's good. Okay, thank you.
Thanks, William. Anya?
Thank you, Chair. Just 2 quick questions from myself. Just in terms of the amount of farmers that are ineligible for this scheme, have the department got any specific figures on that may be knocked out? No.
Well, from the historic years exercise, there were just under 2,000 farm businesses that the department wrote to back in June. Now, as Gregor said, some of those businesses have come back to the department with additional evidence, which the department has considered. Some are back in with that evidence. So there'll be somewhat slightly under 2,000 will be the figure of the number of businesses out.
Okay, and just supplementary to that, George, just in terms of entitlements, will anyone who still hasn't activated their entitlements or haven't activated their entitlements from 2025 be eligible post 26?
Be eligible to apply in 2026, providing they submit an eligible claim and they activate 3 entitlements in 2026. Yeah.
Thank you, George. Thank you, Chair. No.
Okay, Thomas. Thomas.
Thank you, Chair. A couple of things. The money that you're going to save on the capping, where have you that targeted for?
It's redistributed amongst all farm businesses, so it remains within the agri budget.
And much have you calculated how much that would be saving roughly?
Yeah, I think Lorna, you'll have that figure.
It's
have our permission to make it.
approximately 2 million.
Right.
2 million.
Yeah. Okay. The other issue is with regard to getting into qualifying for this scheme. Take, for example, a small farmer hasn't got much land, so rather than put cattle on, or sheep on, or animals on, he's going to just grow grass only, and then use that and sell it on for fodder to other farmers. Is that man eligible for this scheme?
He is.
Okay.
He is.
Yeah. Unless they've been excluded because of the historic years exercise, but if from 1st January 2022, if that's the farm business model, they're eligible.
Yeah, well, for example, in 2022, if he had animals on the land at that time, but he is now doing this other,
He remains
is he still
eligible.
eligible?
Yep, he remains
Okay.
eligible.
Fair enough, thank you.
Enough, Tom?
Yeah.
Any other questions, team? Members? Okay. Thank you very much. Members?
Thank you.
Okay, members, as the procedure is draft affirmative, there will be a debate in plenary. Are you content that the committee supports the SR's draft in the debate? And if so, then we can do that. And if not, so are we supporting SR as drafted? Yeah. Yes. And you'll be we'll have to wait till Anya comes back, and you'll have Anya's part of the debate, isn't you?
Yeah.
Yep.
You need just to know, some.
I'll just wait till Anya's back if you don't mind, just to give her a chance. Yeah.
Is she coming back?
Is Anya coming back? She has her computers there.
You could just move on to that one. We can return to that, okay?
Okay.
If the officials don't mind.
You can tend to sit for a minute or two. I'll just tell you what, we're tight.
So tight
Hold on,
for
that might be Anya coming back in. No? Okay, well, guys, if you don't mind sitting there for a second or two, okay? I'm going to take agenda item 12 because we're tight for time. You guys don't have to take part in this debate now. So agenda item 12, members, if we can go to that, is the SR 2025-161, the Agricultural Schemes Amendment Regulations. So we refer you to pages 257 to 263 of the pack for the SL5 and the SR and the explanatory memorandum. We did receive an oral briefing on the 18th of September and heard that the Department intended to make the SR under negative resolution to implement amendments to existing legislation, which have been introduced as part of the Sustainable Agriculture Programme. If you recall, we heard that DAERA has had to make the SR as it had to increasingly rely on the 1949 Agricultural Act to introduce new environmental focused farming policies and to improve the definition of authorised persons. The rule will also remove offences and penalties and provisions as it came to light that the sufficient provisions exist in the 1949 Act. So members, on the 25th of September, we also heard evidence in closed session from the ESR and that she is content with the approach of the Department in that instance. And there's been no changes to policy content since the SL1 was submitted to the committee. So members, on the 25th of September, we agreed that the Department proceed to make that SR. So I'm now going to put the question to the committee on that SR, that the Committee for Agriculture, Environment and Rural Affairs considered SR 2025-161 Agricultural Schemes Amendment Regulations Northern 2025 and has no objection to the rules subject to the report of the Examiner Statutory Rules. Are we agreed on that one? Yep. Yes, thank you, members. Okay, we're going to return again. Anya, thank you very much. Okay, Anya, in regard to the evidence session that we've just had from the Department, which was the Department all evidence session, SL1, the Farm Sustainability Payment Scheme, eligibility, etc., regulations, Northern 2025. Putting the question, and because as the procedure is draft affirmative, there will be a debate in the plenary. Are you content that the committee supports the SR as drafted in the debate? So those in favour of supporting the draft SR as tabled? Yes? Yep. 4 and 3 against? Yeah? Okay, well, I'm going to be honest, I'm unsure at the moment. I just need some more clarity. It's not that I'm not offering a definitive position on it at the moment, so I'm not going to be offering that I do support it at the moment. So we'll record that at the moment. And
Delegated.
Sorry? So it's... Sorry?
Is it with the business office at the minute, or what's the...
It'll be...
The officials
It'll be led.
Yeah, today, okay.
Yeah. So it's one of these 4 against 4.
Sorry, Chair, so you weren't abstaining there, you were voting against?
I got voting against, yeah.
Okay.
I just said, yeah.
I think we need to always clarify.
Yeah, because I'm not certain, John, so if I'm not certain, I'm not there.
Yeah, but it's a vote against, it's a vote against.
I'm talking about, when I said it wasn't against, it was in the debate in the chamber when I get more clarity on that. So I'm still unsure in around the FSPPs.
This is just, Chair, for you to present the committee's view in the speech. Obviously, you all have individual views as well.
The Chair will make a speech to reflect the committee's considerations and stuff on that. So thank you very much for your time.
Thank you.
Okay. Thank you. Okay. So 12 is now taken, 12 and go to 13.
Yep.
Okay. Okay, agenda item 13. Members, SR 2025-162, the Farming for Sustainability Innovation Payment Regulations, Northern Ireland 2025. Members, I refer you to pages 264 to 271 of the pack for the SL5 and the SR and explanatory memorandum. We received an oral briefing last week and we heard that the Department intended to make this SR under the negative resolution procedure to provide with the legal powers to implement the Farming for Sustainability Innovation Scheme to come into operation on the 23rd of October. There have been no changes to policy content since the SL1 submitted to the committee. Last week we agreed that the Department proceeds to make the SR. I'm now going to put the question on the SR, that the Committee for Agriculture, Environment and Rural Affairs considered the SR 2025-162, the Farming for Sustainability Innovation Regulations. There is no objection to the rules subject to the report of the Examiner of Statutory Rules. Members, are you agreed? Yep. Agreed? Mm-hmm. Any objections? Nope. We're agreed. Thank you. Okay, members, in terms of correspondence, I'm really tight for time. I don't know if you've had a chance to look at the correspondence, but I'm going to touch on a number of items, and if you want to draw my attention, please indicate and we'll do so. The correspondence starts page 273. I'm going to draw to your attention at 14.4. It's on pages 626 to 627 of the pack. Correspondence from the Department dated 3rd of October providing an update on the next steps following the Nutrients Action Programme consultation, which closed on the 24th of July, which raised 3,400 responses. Members, it states that the NAP Stakeholder Task and Finish Group, chaired by an external facilitator, has now been named as Karen Brosnan. Will be established to include organisations across farming, agri-food and the environment, as well as DAERA officials. The group will identify alternative solutions and actions for the Minister's considerations for a finalised NAP for 2026-29. There will then be a further 8-week public consultation, after which final proposals will be brought to the Executive for approval. Members, we have our own NAP event in the diary for the afternoon of the 13th of November, and the clerk will be bringing us a plan for the day in the next couple of weeks. Any comments to make on that? Members, at this stage, you'll get a look at those plans shortly. Thanks to the clerk and the team for looking at that and putting that together. Members, I'm going to move you to 14.6. I refer you to page 629 of the pack to correspondence dated 29th of September from Peter Martin, MLA Chair of the Committee for Infrastructure, to Minister Muir regarding the A5 Transport Corridor. The Committee for Infrastructure has asked what evidence or evidence-based assurances were either sought by the Department for Infrastructure or provided by DAERA to inform the decision taken by Minister Kimmins to proceed with the project. Members, have you any comments? Are you content to note? I'm sure we will be copied into that correspondence. No. Yep. Thank you. There was a note, wasn't it, John? Not a no?
Note, yeah, note.
No. Okay. 14.11, members. I refer you to page 757 to 762 of the pack, correspondence from an individual dated 3rd of October regarding wastewater discharges into Strangford Lough. A copy of Minister Muir's response to the individual query regarding compliance with Water Framework Directive is included. The individual has requested the committee to consider whether this response adequately addresses the legal obligations under the WFD, particularly in relation to consent discharges. Members, have any comments? You content to note, and informally the clerk will speak to your legal services in the first instance and report back, and I think that's the best line of attack for that one, members, if you're content.
Yeah.
Mm-hmm. Okay, and if you note all other correspondence, and then agenda item 15 is the forward work programme. Refer you to pages 53 to 56 of the table papers for the draft forward work programme. Are you content? This is published?
Yep.
Okay, agenda item 16 is any other business? No, okay. And agenda item 17, date, time, place of next meeting is in this room, Thursday the 16th of October 2025, and the meeting is now adjourned. Thank you so much.